May I ask you? I beg to mention these two is IA for correction of order. Maybe listed on 12, my lord.
I am praying for allowing me to move an unlisted motion,
Today,
my
for
lord.
what matter? What purpose?
My lord, what happened, my lord, the petitioner was on leave. It was granted by the competent authority, but my lord, holding her to be unauthorizedly absent, she has been placed under suspension.
Suspension is already issued.
Yes, my lord.
Uh,
My lord, and she is, my lord, holding the.
so what urgent orders you want from the court today?
My lord, as the entire finding in the suspension order is, my lord, purpose, lordship may interfere with the.
Set aside on the same day.
No, my lord, for staying the.
How can there be a stay? Tell me. They've already issued. We'll examine the matter. Suspension order has been issued, placed under suspension.
My lord.
Now to stay that suspension would have the effect of putting her back
My lord,
into reinstatement.
another aspect is, my lord, she was holding the suspended post of district elementary education officer, but she has been suspended as inspector of schools.
We'll examine that. I'm asking you what is the urgent orders you require as an unlisted matter.
My lord, for,
It will come as a listed matter.
for an interim order, my lord.
So we'll examine all that. Let the matter come up whenever it is. Have you filed a writ petition?
Yes, my lord, it has been, my lord, I have got
Defects
the
cleared. So you list it on 12th. We'll examine. 12th.
my lord, has some personal difficulty. That is
Personal difficulty, then it goes after the holidays.
Can it be on tomorrow, my lord?
Not
If
tomorrow.
possible, my lord.
What is the urgent order? That is what I'm asking. Had the suspension not been issued, we could have passed some orders. Now, what urgent orders you want?
My lord, an interim protection,
What interim protection for what?
staying the suspension order, my lord.
That is as good as giving you the final relief.
Or, my lord,
It is not a punishment.
it's not a punishment, but
then-
it should be reasonable, my lord. But it is a stigmatic order, my lord.
Now, how can it be stigmatic if it is not punishment? We'll have to examine all that. They'll have to be confronted with the record. The respondents are required to file something. What urgent orders can we pass once you are suspended?
Tomorrow, my lord, if possible. Tomorrow, my lord, possible, my lord.
No, not tomorrow. You tell us 12th is difficult. We'll have it on 19, 18, 19 if you want. 18,
12, my lord.
12th.
My lord.
All right, then 12th. 12th.
On 12, my lord, I will make a mention for upgrading. my lord.
Yes, all right. All right. 12th.
Oblige, my lord.
May I please, your lordship? I beg to mention for listing a WPC of 2023. This is basically a pension matter. What happened, your lordship, is that
This is what?
a pension matter, your lordship.
You want it listed for admission?
Yes, your lordship.
Admission
No, your lordship, for orders, your lordship.
for orders. Why?
Because, your lordship, my father was getting the pension, and since he died, I was receiving the pension. Then
Family
suddenly
pension.
my pension got stopped. So therefore, it has become difficult for me to survive, your lordship.
List it in the.
And I wanted to fix it on 12th.
No, not 12. Not 12.
An early date, your lordship.
No, early date.
Tomorrow.
Court must give it. 19th. Oh, 19th, we are already docket school. 22nd.
19th, your lordship.
22nd. 22nd.
Much obliged.
Any auspicious day? 19th is auspicious for you.
No, your lordship.
No. Then 22nd.
Much obliged.
22nd. Yes.
May it please the lordship. Lordship, I beg to mention item number 53, lordship. Here we need to obtain some instruction from the client, lordship.
53, you want an adjournment.
Yes, lordship.
53 at the request of learned counsel for the petitioner, matter stands adjourned for 2 weeks.
Obliged.
May I please, lordship. Lordship, I beg to mention a admission matter for listing, lordship. Any date of next week.
What matter?
Admission matter. He has been
Admission
terminated.
matter.
Yes,
All right, let it come on 22nd January.
lordship. May I please? Lordship, I beg to mention for listing, lordship. It was fixed on 7, lordship, but it was a holiday, lordship. Therefore, matter has not come.
For what admission?
Admission, lordship.
24th,
Yes,
24th
highly
January.
Lordship, another pay, I have a new cases, lordship. New cases.
For listing.
For listing.
It will come regularly. Has it not been filed? Automatically it should
Lordship,
be
it was
listed.
filed before vacation, lordship, but same has been lying pending. Therefore, I am.
24th, let it be on
Lordship,
20
it is a new case, Lordship, so before vacation,
before vacation.
yes.
12th, all right, 12th.
highly applied.
If it may please your lordship. Your lordship, there were two matters pertaining to pension as well as other ancillary benefits. It was supposed to be listed today, your lordship, but due to some reason, it has not been listed. Your lordship had allowed mentioning previously for today. Your lordship, one is for
Have
admissions.
you
and-
checked up?
We had checked the registry. Due to some technical reason, it was not there. They asked us to mention again, your lordship.
All right, then 24th.
24th. Much obliged. Your
Yes.
May I please, your lordship, with the consent of other side, I beg to mention item 37 of today's daily list.
Hmm.
I am for respondent number 1, 2, and 3.
Yes.
Lordship, we need to file affidavit.
Have you informed the petitioners,
Yes,
council?
Yes, lordship. 4 weeks time may be granted.
What is your name?
K. Kolita on behalf of KK Parasar.
Mr. K. Kolita, Learned Council, on behalf of Mr. K.K. Parasar, Learned CGC, submits that reply. What do you want to file?
Affidavit, lordship.
Requires some time to file the counter affidavit. Consent has been obtained from the petitioner. Matter be listed after 3 weeks.
Obliged.
May it please your lordship.
Yes.
Lordship, I would to mention on behalf of the department, item number 7 to 13, lordship. These matters pertains to although 2015, lordship. Mr. R. Majumdar is handling this matter, lordship. And some of the files are misplaced, lordship, in the office. So we are going to reconstruct the file. Lordship may fix the matter anytime.
No, we call Mr. Mazumdar, we'll hear him. 15 matters, we can't adjourn like that.
Any data.
No, wait, you call him. We'll hear him.
Files are misplaced, lordship.
You allow the matter to be called up.
Lordship.
Will you renew your prayer? We'll consider.
Lordship.
First, who is the council leading the argument here?
Mr. R. Majumdar is there.
So you call him.
He is not, lordship.
You call him
I will
when the
inform-
matter is.
Although we have taken consent from the other side.
You call him. Let us
Lord-
find out what is the issue here.
Lordship.
All right. Yes.
Then lordship may take up at 2, lordship. Whatever.
At 2 all right.
I will inform Mr. Majumdar.
At 2. Yes, Mr. Manan.
May it please your lordship. This matter relates to admission in the medical college. On the last occasion, your lordship, this honorable court has
Some
noted down
instructions
that
are sought for. Has the order been passed?
Lordship, we
Lordship,
have
kindly
communicated,
go through the earlier
we have
order,
communicated,
Gone
the-
through it.
specific on that point.
we have communicated the decision of the state level caste scrutiny committee to the director of medical education, Lordship.
Now, only thing is that there was
Part-
no fault on the part of the petitioner.
First page is the
He is
letter,
using this hearing.
communication letter, and the page number 3 is the findings.
So who's for the director of medical education?
Mr. B. Gogoi.
Gogoi was there in the last.
Where is Mr. Gogoi?
Gogoi was here.
So it has now gone to director of medical education. Then director will pass an order.
Okay.
They are required to pass the order.
That was what on the last occasion, Mr. Gogoi has said that after their decision, then it will go to the director, then the director will pass an order. With regard. So
They heard. Have you seen this?
they have given me a copy.
Heard Mr. Y.S. Manna, Learned Counsel for the petitioner, also heard Mr. R.M. Das, Learned Standing Counsel
Lordship.
for Department of Social Justice and Empowerment.
Lordship.
Mr. Das has produced before the court a communication dated 9/1/2024, issued by the Joint Secretary to the Government of Assam, Department of Social Justice and Empowerment, to the Director, Medical Education, communicating the decision, communicating the minutes, enclosing the minutes of the state level scrutiny committee meeting held on 29/12/2023 and 30/12/2023 in the on the issue of the caste certificate. What certificate is it?
It is a
Tea garden.
ex tea garden liver category.
On the issue of the
OBC, actually it's an
verification-
OBC under the CGL
verification of the certificate issued to the petitioner as OBC-EX-TGL category. Stop. Mr. Das submits that in terms of the minutes, after due verification, the authorities have the state level scrutiny committee has held that the claim of the petitioner is genuine and he belongs to the OBC-EX-TGL category. Stop. Mr. Das further submits that since the matter has been communicated to the Director, Medical Education, now appropriate orders are required to be passed by the Department of Medical Education. Para. Yes, Mr. Gogoi.
My lord, let me have the instruction.
Mr.
Because
Gogoi,
this year
learned
it won't be possible.
Standing Council Medical Education submits that he would like to obtain the instructions as to the status of the orders required to be passed by the Director Medical Education. When can you get it? Friday?
Immediately after vacation. No?
Why not on Friday?
Friday. Yes.
It's only a question of
they
what orders are to be passed here.
No, only we'll have to see whether it can be accommodated in the next year, because this year it won't be possible. Cannot be there, cannot be admission in the midstream.
No, but it was not his fault.
Even then, my lord, the Supreme Court orders that they are not.
This is this is tragic.
Only thing, my lord, I will place the order of the DMA.
Let it be on 22nd then, Mr. Mannan.
I have
22nd
no
of
problem here, because what has happened initially, he was allowed to do the classes because of the earlier order of this on report, interim orders by the division bench at the time. But this order, his case was passed prior to the order of the final order of the division bench. So they were given a time of about, it was a little bit time to finalize that.
You
but they did
examine
not-
the apex court orders if you think and
No, then what they have done, the other two persons in the division bench, they were accommodated. This was a single bench order, they kept it pending, so I have to come again. Now the court has taken it up and things are moving. And because I think your lordship has seen in a short dates, the court has given and there things are moving, and at least to this stage it has come. If we can accommodate, then it will be better. Otherwise, your lordship then will have to take a call what to do, because neither it was our fault. Because the person concerned, he was admitted, then his admission was cancelled without any reason, your lordship. Being a genuine candidate, that's the reason.
all right, let the director,
Let him pass.
let the order passed by the director be placed before the
Yes.
court on the next date fixed. List on 22nd.
Our names may be shown, but
Names of all the councils, including the respondent councils, will be reflected in the cause list by the registry.
Not.
You are appearing? Mr. C.K.S. Borwa appears for the district commissioner. Dibrugarh. Dibrugarh.
Because
Let's
if,
take
if it continues, your lordship, otherwise also, I think first semester exams.
You will have
are
to
al-
examine the directions of the apex court.
Yeah, but there was an issue here, because this matter was passed prior to the division bench. So that time there was some, I think 15 days, 16 days period was there to finalize the thing. That is why this was passed, but they didn't do. Ultimately, the division bench order came, and then the matter went that way, that since he did not go through, he came before the Honorable Court second time. Then they have started taking the cognizance of all these matters, whether it is there or not. Then finally, after
Why,
direction. of
why
the
was it
Supreme-
cancelled? Somebody complained. Why was it cancelled?
It was with regard to another matter. here. Another matter,
However, the
somebody's
Honorable
case.
Court directed that
It was
all
a
the
blanket
selected
order.
candidates under the T-Tribe community will have to be examined, irrespective whether they have approached the Honorable Court or whether there is any complaint against them.
Is
So
it-
he examined everything.
It is in terms of the coordinate
Yes.
bench order.
Yes.
This is a coordinate
Thereafter,
bench
my
order
lord, when
which
the
was stayed
report
by the
came,
single,
Honorable Court
division
directed us to implement the order. And it was found that, my lord, as per the report of the state level committee, the petitioner was found to be not eligible at that point of time. So we have to cancel it, and it was in the last day, when the 29th that order was passed. 30th was the last day for admission, as per Supreme Court's direction. So this was the position.
Then this was extended by 1 month.
No, not extended. The Honorable Court, Supreme Court has passed one order whereby the High Court has got given the power to extend the period for another 1 month, that is for 30 days. And additionally, two seats can be increased by the High Court if it is found that, my lord, some genuine candidate is left out. That exercise has been already carried out by the division bench of the Honorable Court, whereby 2 persons has now been already been inducted. So there is no seat
He's the
seat
third.
left out.
He's the third.
I am the third.
Third.
And here, this person did not go to the division bench, he remained in the single bench itself because his matter was not disposed.
Okay.
So
When-
that's why he is now losing the year.
And
Alright.
my lord, first semester has already started examination. So
But it's not his fault.
no, we understand, my lord.
Not
Not
his
a
fault.
fault of ours also, my lord. In fact,
But what can be done now?
Anyway,
22nd.
your lordship, let it be on 22nd. March of-
May I please law. The matter was regarding non-approval of the transfer of the petitioner. Last time.
Yes, some.
Lordship, here I have received the instruction, Lordship.
Hmm.
For lack of proper document by the furnished by the petitioner, the DLC could not recommend her transfer, Lordship. And even in the idea that online login also, the petitioner's ID is not present.
Have you seen the last order?
Lordship, we have to obtain that consideration was there, Lordship.
Last order, your colleague submitted that online applications are presently under scrutiny.
Lordship, all the online applications for transfer are under consideration.
Hmm.
And upon verification, it was found
Where is that? You
that
have to-
that
Have you
DLC
communicated?
DLC report I have just
Have
received.
you
Lordship.
communicated to the petitioner?
No, Lordship, I have just received it.
Let us, where is the instruction?
You communicate.
Lordship,
Why have you not communicated?
Lordship, just now I received through WhatsApp, Lordship, and there was lack of proper because of the furnishing of the lack of documents, Lordship. Our
Heard
application was
the counsel for the petitioner and Mr. T.N. Sharma for the elementary education. So Mr. Sharma submits that pursuant to the scrutiny of the online applications made by the petitioner, it was found that there were certain documents which were not furnished, and accordingly, her case could not be considered for approval. Stop. He submits, he would like to place these instructions before the court on the next date fixed. Learned counsel for the petitioner submits
Check.
that no such instructions have been, no such order has been communicated to the petitioner as yet. Accordingly, matter stands deferred by 2 weeks. The respondent will communicate the orders passed in respect of the application, online application of the petitioner within this period of 2 weeks.
Lordship.
Place the matter again on 20. On 2nd of February,
Lordship.
2nd February.
Whether parties to non-payment of subsistence allowance.
Non-payment of?
Subsistence allowance.
I was directed to obtain instruction, my lord. I have received a written instruction, my lord. My lord, matter is, my lord, on 5th of August 2022, government has informed the, my lord, AG for grant of subsistence allowance. Now, pay slip is not received by this office, my lord.
AG, permission for the AG is required, my lord, to open.
Yes, AG.
That's why, my lord, AG, counsel for,
Those
SK
for the
Mehdi was
AG.
there.
Is the AG a party?
Yes, respondent number 4.
Why party रहा है ना? वो तो AG.
You call the AG, call the standing council. Please request the standing council to be present. We'll take it up.
This instruction will be kept on record.
We are keeping it on record.
Yeah. Obliged.
We'll take it up at
After some
after some time. After
motion method.
if he's available, we can take it up now. Yes, next. Yes.
Please, my lord. A petitioner was appointed as my lord secondary teacher in the year 1995, my lord.
Mm.
Thereafter, my lord, his service was normalized, my lord. Then, my lord, allowed.
You are praying for a similar order.
Yes, my lord, there is
Page
similar.
number
Page
80.
number 80, my lord.
Same order.
Yes, my lord. My lord, para number 3, my lord.
Hmm.
Their regular scale of pay were given to them after 20 October 2012. In my lord, from 2004, my lord, regular pay scale was given.
Okay.
That is my lord.
Mr. Sharma?
Lordship here, because one of the prayer of the petitioner is also for area salary, Lordship.
No, my lord.
So we have to verify it, Lordship. Lordship may issue notice, we will verify it and Lordship, because
You whatever
no,
is to be paid, you pay, and area salary you verify and pay.
Yes.
we need to verify, Lordship, because there are certain illegal and irregular teachers also over there in those periods, Lordship. So we have to.
Is it in my lord that para 6, my lord, 84, my lord. Page number, my lord.
Okay, you go through this order, we'll take it up on 12th.
On
12th.
12th.
Yeah,
At
my-
12. On 12th.
12th.
Lordship.
Friday.
Lordship.
You go through it
Lordship.
and then tell us.
Lordship.
My PR, my lord, for area salary is not there, my lord. I am not. In PR section, there is no area salary.
Prayer number 1. Read in the nature of mandamus or like should not be issued, directing the responsible authority to settle and make the current as well as arrear regular pension death come return, Lordship. We will verify, Lordship.
Okay. Please, again on 12th,
Lordship.
enabling Mr. Sharma to complete his instructions as to whether this matter. We'll just write, complete your instructions. You let us know whether it is covered by the order at page 80. List on Friday. Yes.
Yes, Mr. Rashid, petitioner is a assistant teacher of, he already been retired. He was a teacher of the Assembly ME school. Lordship, his service also approved, but Lordship, he's a drop teacher and all the teachers of the schools are already been regularized.
Hmm.
In terms of the order dated passed by this honorable court, that is at page 68, Lordship. Page 68. Annexure 10, page 68, Lordship. 68. Annexure 10. In terms of that order, all the teachers of the school were regularized, Lordship. Therefore, Lordship, suddenly, the relevant portion is that
Yes.
para 11. Now, in terms of the order, all the teaching and non-teaching staff of both the institution headed by Sushil Kumar Sarkar and Dilip Kumar Burman will be entitled to receive the admissible salary upon proper verification of the working teacher and their period of service established by the education department.
You're praying for regularization.
Yes, Lordship. Therefore, Lordship, suddenly, Annexure 10 of it, Annexure 12. Suddenly, they, at page 82, Lordship. Suddenly, they have rejected our case. It was placed before the several official of the LMT Education Department, but suddenly, by the order of the Deputy Secretary of the Government of Assam, in this annexure 12, page 82, this service was, the regulation was rejected. Thereafter, Lordship, we have filed one we have filed a read petition that is at annexure 13, page 87. 87, and relevant portion is at page 89. Lordship, relevant portion, page 89. From the state point of view, we interfere with the communication dated 10/6/2019 and remand the matter back to the authorities in the government of Assam in the elementary education department to give a fresh consideration to the claim of the petitioner for regularization and salary as has been paid to the other employees of Nisalimari ME school headed by Sri Sushil Kumar Sarkar as per the order dated 29/3/2014 and pass a reason order. And Lordship, thereafter, in terms of that order, Lordship, annexure 18, Lordship, page number 103. 103. The relevant portion is at page 104. Para 2, I'm reading, I'll read out. The service of the Devacharan Das, assistant teacher, and Sri Madhucharan Sarkar, Gate 4, Chowkidar, are to be regularized against the vacant posts indicated by the Director Elementary Education, Assam, by his proposal so and so after due approval. Till that time, it is pending before the respondent 1 and 3, that is a finance department. Not yet any order has been passed by them. That's why already I have been retired from the service on 31/1/2021. The matter is now placed before the finance department.
Yes. Still now, no order has been passed.
No.
Yes, finance, can you obtain instruction here? Page number 103.
Yes, 104 precisely, my lord. All the dispute has been set to rest. Now, my lord, from the writ petition, it doesn't transpire, my lord, that the education department had sent any formal proposal to the finance SI department.
You find out and let us know.
Lordship may be pleased to issue notice, my lord. I will have to find out, my lord. Because it will take some time, because we do not know the exact proposal number. Lordship will kindly direct the finance department as well as the education department, because the direction is clear at page 104. For a moment, my lord, kindly see page 104.
104, yes.
104, that is the part of the speaking order. They have now regularized 104. Page 104, my lord. The first page, decision. Lordship will kindly come to, my lord, the serial number 1, the second paragraph.
Yes.
Page number 104, the services of Sri Devasaran Das. He is the petitioner out here. And one Sri Madhucharan Sarkar, he is not a petitioner, are to be regularized. Are to be regularized against the vacant post indicated by the Director of Elementary Education by this proposal after due approval concurrence of final. So that concurrence and approval, the Education Department will have to move a proposal. That, my lord.
Then let the education send the instruction and tell us whether you have sent the proposal.
My lord, that's it only.
Third learned council, this petition is filed by the petitioner. Agree that the order, agree that the decision of the elementary education department in respect of regularization of its services has not been implemented as yet. So, learned council for the petitioner submits that by order dated 20 July 2021, passed by the Elementary Education Department. The department accepted the claim of the petitioner that he is to be regularized against the vacant posts indicated by the Director Elementary Education as per his proposal mentioned therein. So, Learned Counsel for the petitioner submits that although this order was passed in July 2021, till date no orders have been issued regularizing the services of the petition. Representations filed before the authorities. You have not filed any representation.
Yes, Lordship, I filed.
Representations filed before the authorities have not
Um,
been
okay.
addressed.
Pre-representation was filed,
Stop.
page number 20.
All right,
then-
all right, all right. Let Mr. P.N. Sharma, Learned Standing Counsel, Elementary Education, obtain instructions in respect of the order dated 20 July 2021, in respect of the consequential steps taken by the department pursuant to the order dated 20 July 2021. So the Learned Counsel will apprise the court the next date whether the proposals for approval or concurrence of the finance within bracket SIU department has been forwarded, and if so, then the complete details of the proposals, the particulars of the proposal, number, etc., be placed before the court. Mr. R. Borpujari appears for the finance department. List again on 24th.
4th,
24th
24th of?
January.
No, Lordship, I'll be out of session. So like, can it be on February 2nd or 3rd?
All right, 2nd February.
God bless.
Yes, Accountant General.
Lordship may feel the matter immediately after the Bihu vacation. I will take instruction.
All right.
Mobile.
Mr. A. Patwari appears for the petitioner. Mr. T.C. Sutia, Learned Additional Senior Government Advocate for the respondent state, has submitted before this court that instructions have been received from the department that for grant of subsistence allowance to the petitioner, a pay slip required to be received from the Office of the Accountant General Assam has not yet been received, and accordingly the same could not be released to the petitioner. Stop. Mr. S. Hassan, Learned Counsel appearing for the Accountant General, seeks liberty of the court to complete his instructions in the matter. List again on 24th of January.
I am for the respondent.
Mr. Hendig appears for respondent number
Revenue Department.
for the Revenue Department.
I am A. Hassan.
A. Hassan, sorry. A. Hassan.
All right.
As per Office Note 81/2024, steps as directed by this court had not been taken. However, when the matter is called up, none represents the parties. Matter stands adjourned for the day.
Here, your lordship, there is a direction for learned state council to file an affidavit, your lordship, by order dated, your lordship. We have also filed an additional affidavit, which is part of the record, your lordship. If your lordship goes to the order.
Yes, state respondents, your affidavit is not available. Have you filed it?
In this case, as per the order dated 15/7/2021, the learned counsel for the accountant general madam had made a confirmed statement saying that the petitioner has already got the requisite relief because he has been instructed that the pension payment order has already been released in favor of the petition fund. Thereafter, a confirmation was required, madam, from their end as to whether this has been done, completed or not.
Lordship, so far as the issue of pension is concerned, pension we received, but there are other prayers, your lordship, which is there in this.
Have you seen the last order? Last orders. Sorry, not the last order. Who is respondents number 2, 3, and 4?
PNRD.
2 and 3.
PNRD.
You are required to file some affidavit. What are your prayers here?
Lordship, we have your lordship specific prayer is your lordship that we have not got revised pay scale, your lordship. That's one. So ultimately, your lordship, the pension will have to be fixed, your lordship, on the basis of my last pay drawn after your lordship revised pay scale, your lordship, on the basis of revised pay scale, your lordship. That, and secondly, your lordship, some amount, your lordship, due to the petitioner under your lordship nil bill, that has not been paid to the petitioner.
Madam, kindly have a look at the prayers, madam, that page 12 and 13 of the rate petition.
Yes.
It says that prayer A, madam, para 29. For writ of mandamus or a direction of the like nature should be not be issued to plead the writ petitioner deemed to have been retired on superannuation from the post of subdivisional planning officer and secretary or senior block development officer, and to fix all retirement benefits due to the petitioner applicable to the post of subdivisional planning officer and secretary or senior block development officer. B, my lord, release the pensionary benefit as stated therein above due to the petitioner within the stipulated period with interest applicable under such a situation. An interim pay is there, my lord, at prayer D, my lord. This has already been satisfied.
No, your lordship, that has not been done, your lordship. Not on
Because
the basis of.
my lord may kindly have a look at order dated 15/7/2021.
If
The
they file an
council,
affidavit, your
the
lordship.
council on behalf of the accountant general, my lord, standing council, he's made a statement which is recorded in that order in the third paragraph.
Now, what do you want?
Lordship, so far as this is concerned, your lordship, in 1984, your lordship, I have, that I was to be promoted, your lordship. But your lordship, due to pendency of the disciplinary proceeding, etc., your lordship, they did not promote me, your lordship.
That you'll have to challenge it.
Which, your lordship?
Your claim for promotion.
Yes, your lordship. Because I have, I am saying that, your lordship, that promotion, your lordship, to which I was entitled, your lordship, the procedure they have not followed. I have, your lordship, annexed.
But that is not the issue here.
Yes, your lordship.
Where?
That's what, your lordship, we are praying for. He has the pensionary benefits, your lordship, not praying.
So, show us the paragraphs where you have made these averments.
Lord. Your lordship will get it, your lordship, from paragraph 5 onwards, your lordship. The government of Assam promoted some of the block development officer by the order dated 25/1/1984 as subdivisional planning officer secretary, but the name of the petitioner was not found in the list. However, so and so, who was junior to the petitioner according to the final gradation list dated 10/9/86 was promoted. In the state gradation list, the petitioner was placed at serial number 78 and Habibur Rahman name was at serial number 77. Then, your lordship, then the petitioner was again suspended on this. Because of these proceedings, your lordship, he was ultimately not promoted, your lordship. Now,
So now you'll have to now claim for promotion to that post.
Lordship, that's what your lordship, I am saying that since I have already been retired, and your lordship pursuant to this honorable court's direction, your lordship, that is that your lordship will get it at page, your lordship, 50, the final direction of this honorable court. Your lordship. Page 50. The disciplinary proceeding ultimately after my retirement has ended in this, your lordship, in 2013.
Page 50.
50.
Yes.
Now, this was, your lordship, after passing of this direction, your lordship, disciplinary proceeding has finally come to an end, your lordship, when the entire proceeding is passed by this honorable court, your lordship. Now, your lordship, only then, your lordship, I can claim, your lordship, that I should be promoted to the post of, your lordship, subdivisional planning officer.
You are saying that in terms of the order passed by the coordinate bench on
Lordship.
19/8/2013.
Lordship. The disciplinary proceeding ultimately came to an end, your lordship.
Right. Then
Now therefore it was their duty, your lordship, as per their office memorandum, your lordship, to consider my case, your lordship. I retired from service in
no, but
2001.
they having not considered, you have to pray for it.
That's why, your lordship, I am praying this prayer, your lordship will kindly note.
Not then.
A writ of mandamus or a direction of like nature could not be issued to treat the writ petitioner deemed to have retired on superannuation from the post of sub-divisional planning officer
No, that
and secretary of senior block.
you'll have to urge this matter with your proper pleadings that your gradation list number so and so was has been superseded. You have been superseded by so and so.
That's
The
what
DPC minutes. Where are all these?
Your lordship, DPC minutes, your lordship, that is not available with me. That's why, your lordship.
At least you can challenge the DPC orders.
Lordship will kindly see, your lordship, that's why, your lordship, on last occasion, after going through, the honorable court directed them to file an affidavit, saying that, yes, what is your stand on this?
No, but their stand apart, you will have to make out your case first.
Lordship.
Your case essentially is for release of pension.
Yes.
At the correct scale.
No, release of pension, your lordship, I retired as, your lordship, they are paying me pension as a BDO, your lordship. Now, I am entitled to senior BDO, your lordship. That's what my
So
prayer.
that senior BDO will be subject to some order passed by the department or by the court
Lordship,
holding that you ought to have been promoted, not
Lordship.
promoted, notional benefits be granted.
Lordship.
So where are the pleadings to that effect?
That's why, your lordship, that the para 5 and the grounds, your lordship, will find, your lordship.
No, this is, I think, stretching it a little too far. Your pleadings will have to be completed. If you're entitled, you want amendment, you do whatever amendments are there. But your prayer essentially is for pension. Merely saying that it must be released in the correct scale doesn't mean that you are making a claim for promotion and be given the notional benefits.
Lordship, that's what my.
Because you see, if you make this submission now,
Lordship.
then the respondents are to be given some time to respond to these contentions.
Lordship.
But where are the contentions in the first place? Where are the averments in the first place?
Lordship, when you, lordship.
Where are the averments to say that you are claiming promotion over so and so who had superseded you because of this, and this having been set aside? Now review DPC was required to be held. Where are these pleadings?
Lordship will kindly see, your lordship. I am not making a prayer that I am putting challenge to the promotion of Habibur Rahman, your lordship.
No, you may not. But if you are claiming notional benefits, then your claim for that particular post has to be agitated.
Lordship will kindly see, your lordship. The procedure they have to be adopted, your lordship. That has been given in line to office memorandum, your lordship, which I have annexed, your lordship. Now it is their duty, your lordship, to follow that office memorandum, your lordship.
Where are these office memorandums?
Lordship will give it, your lordship. Page 33, your lordship.
33.
This was the office memorandum.
This is 76.
Lordship, then, your lordship, that was governing my case, your lordship, at the relevant point of time, 86. Now, your lordship, after fighting series of litigations, your lordship, I have finally got the benefit, your lordship, of pension at least, your lordship. Now, this was the office memorandum which governed the field at the relevant point of time, your lordship. Now, they have to follow this. They have not followed this, your lordship. My prayer is not.
Your case was never placed in a seal
No,
cover.
your lordship, that's what, your lordship.
But did you urge all this before the court?
Lordship. There are 12, your lordship, that by an office memorandum dated.
No, you had approached this court earlier.
Earlier, your lordship, because your lordship, earlier cases, your lordship, your lordship, after your lordship, I have put to challenge your lordship, my suspension, reinstatement, and when reinstated, your lordship, they initiated a disciplinary proceeding and suspended me, and your lordship, during that disciplinary proceeding, I got retired, your lordship, suspension.
Where is the
It's your lordship, the petition, your lordship, I admit, your lordship, that slightly sketchy, your lordship.
not slightly?
Your lordship.
Slightly is putting it very mildly. So,
That your lordship, I later on.
so you are better equipped to think about and take necessary steps if you want, but
Basic facts, your lordship, it has placed, your lordship, that he has not been considered at all, and your lordship will kindly see the.
when was the promotion made?
84, your lordship.
Then
Lord.
84, now you want a review DPC.
Lordship, because your lordship, I have been fighting in.
You may have been fighting, but you did not urge this point. Nobody thought it necessary to urge this issue.
Because your lordship will kindly see that those, I was under suspension, your lordship, 84.
No. Seal cover.
89,
If you are within the zone of consideration,
yes, your lordship.
your matter should have been placed in seal cover.
Lord. But your lordship, there's one judgment of the apex court. It says, your lordship, that when it is the duty of the authorities, your lordship, to do certain act, if they don't do that, your lordship, for that, your lordship, delay should not be come as a bar, your lordship. Because your lordship, these are the matters, your lordship, and your lordship will kindly see his situation, your lordship. So 2001, he retired. Till 2013, he had to fight.
Yes, Mr. Dasgupta, what do you say? You have not filed an affidavit.
No, madam, we haven't filed.
You don't want to file apparently.
Madam, we filed,
2015 matter, so you don't want to file.
Actually, the instruction, since there was already a confirmed statement given by the standing counsel from the AG, my lord, as regards the specific relief.
No, that is all right, but
now
now he is urging some other issues.
that
Unless
is
he
not there in
filed,
the writ petition. Others we'll have to take fresh instruction on that, madam.
no, not instructions, you are required to file an affidavit. You did not file in spite of opportunities being granted. Several opportunities were granted.
I was under the impression that since the relief that has been.
Oh, you are under wrong impression. If you are under wrong impression, it can't come to your aid.
Opportunity may be given, I'll get the.
When there are orders of the court passed, what is the question of having an impression? Either you file or you don't file.
We'll file, madam.
No, you will
The
file, but this is a
prayer-
2015
the
matter.
prayer
50
that-
more years will be
The prayer
required.
that the petitioner is agitating now, madam, that is not there actually in the writ petition, but now since he's made the prayer.
You show us do you have the gradation list?
Yes. That is the page. 8 plus.
And where are your service rules?
That's page 19, your lord.
Highly given matter.
Page 27, your lord.
Where are the rules?
Rules, your lordship, there are, so far as this Panchayat and Rural Development Department is concerned, your lordship, there are no separate set of service rules that I have.
But you have not filed your affidavit.
We have.
There is nothing to reflect what the state did insofar as the claims made by the petitioner.
Actually, what had happened in this case, my lord, earlier there were 4 respondents, my lord. And it was on 15/7/2021 that the standing council, I mean, the respondent number 5 was included, my lord, and thereafter they made a statement saying that, the relief that has been sought for has already been like almost about to be given, my lord. And so thereafter, actually, it was them actually who was required to actually give the confirmed statement as to whether this relief as sought by the petitioner was provided or not.
Show us where is your position in the gradation list.
Lordship, may kindly come to page 27, Your Lordship.
27.
7. Serial number 76, Vaikuntanath Chetia. And the Habibur Rahman, serial number 77.
There are 2 petitioners.
One petitioner, Habibur Rahman, that's the person who superseded on 1980,
Okay.
whose claim was found.
You have not arrayed him as a party.
No, Your Lordship, we have no grievance at all, Your Lordship. And in fact, Your Lordship, we are not seeking, Your Lordship, that area, Your Lordship. That notional benefit, Your Lordship, that.
Yes. Then
Your Lordship, thereafter, Your Lordship, that then this office memorandum, Your Lordship, which they should have followed, Your Lordship, they did not. And then, Your Lordship, I have to come before this honorable court, Your Lordship. First, it was in 1998.
see, there are 2 ways to now deal with the matter.
Lordship.
The first option is to close it, give you liberty to approach the authorities for your claims. The other is if you can furnish some materials to show that you are within the zone of consideration, was left out, because expecting the government to file an affidavit now with all these records is
Difficult to.
meaningless.
Lordship, we will try to do that, Your Lordship. And in the meantime, let them file an affidavit also, Your Lordship.
No, your wishful thinking of them filing an affidavit has not fructified for the last how many years? 10 years? 9 years?
9.
Then
Rest, my lord, the first option may be.
no, there's no difficulty in the first option, but I could foresee the consequences of passing some order which will again be challenged before this court, or not passing an order leading to a contempt.
No.
The government must be little proactive in these matters. They are, after all, your employees. If a man is saying that he is entitled to promotion, you examine the matter and pass your orders.
The difficulty was that no specific prayer in that regard was made in the report.
Oh,
Otherwise,
no specific prayer, because he is a citizen, he doesn't know how to claim or what to claim. But as a department, you know that there is a process for selecting people for promotion.
that
Then who's going to remind you about your responsibilities as per the rules? Do you have any documents?
I will have to, Your Lordship, contact my client, Your Lordship, for that.
All right. It is submitted by by the learned counsel for the petitioner that although the petitioner has received his pensionary benefits, however, he is still aggrieved as the said pension was not calculated at the appropriate scale of pay. Stop. The learned counsel for the petitioner submits that he ought to have been promoted to the post of what? Senior BDO.
Senior video.
Senior BDO. And his claims were overlooked only on the ground that he was placed under suspension. Stop. The said suspension was finally interfered with by a coordinate bench of this court by order dated
1993.
when was the order passed?
Lordship, the appellant directed to 1980-2013.
19/8/2013. Stop. Learned counsel for the petitioner submits that in terms of the procedure prescribed, the petitioner's name ought to have been included in the zone of consideration for promotion, for selection and promotion to the next higher post of BDO, senior BDO, as the petitioner's name appeared at serial number 76
Annex.
in the gradation list
Annex 3,
enclosed, a gradation list stated to have been published by the department and which is enclosed to the writ petition at Annexure B, capital B. Final gradation list. Learned counsel for the petitioner, referring to the gradation list, submits that the officer whose name appears at serial number 77 was junior to the petitioner, as is evident from the gradation list, but he was promoted to the higher post of senior BDO, overlooking the claims of the petitioner. Stop. At this stage, the writ petitioner does not wish to challenge the promotions given to the officer at serial number 77 or any other officer junior to the petitioner who had superseded the petitioner for being promoted to the next higher post of senior BDO. Stop. He, however, submits that when did he superannuate?
2001.
In 2000, which month?
31, 2021.
With effect from 30/01/2001, the petitioner superannuated from service, and thereafter his pension has been released. However, it is his claim that the pension, it is the claim of the petitioner that the pension ought to have been released. It is the claim of the petitioner that had the petitioner's claim not been overlooked, he could have been considered for being promoted to the next higher post of senior BDO. And if such an order was passed, he would have received better financial, he would have received a higher scale, and consequently his pensionary benefits would have also increased. Stop. However, because of the apathy of the department, his claim was overlooked and not considered even after the interference of the suspension order by this court, by the judgment and order dated 12/9, is it? 12/9/2013 in WPC so and so.
1980.
19/8/2013. Stop. Learned counsel for the petitioner submits that under the rules and procedure prescribed by the department, petitioner was entitled to be considered by the department for being promoted to the next higher post of senior BDO. Stop. Para. Mr. Devnath, Learned Standing Counsel, PNRD, submits that since the prayer made in the writ petition is with effect, is in respect of release of pensionary benefits, and the same having been released as is reflected in the order dated
15/7/2021.
15/7/2021. No affidavit was required to be filed. However, if the petitioner now seeks to agitate his claim for notional benefits for the post of senior BDO, then the department is required to respond accordingly. He therefore prays for some time to complete his instructions and file counter affidavit if so advised.
Subsequent order of promotion of my juniors, I have brought on record by additional affidavit.
Let the matter be listed again on 2nd of February. Second of February.
Obliged.
Mr. Chakraborty, you are appearing in the matter. MSM Bhattacharjee for
I have for respondent number 1, Lord.
respondent 1, Mr. Chakraborty for respondent 4, Accountant General.
That's 7 to 30.
Ah. That was at 2 p.m.
At 2, Lordship.
Oh, at 2. Okay. None appears for the petitioner on call. Mr. Devnath appears for the PNRD department. Matter passed over for the day.
Obliged.
Division bench decided the matter.
My lord, that issue where before the division bench, we have challenged the rule, your lordship, rule 4, and division bench has stated that rule, your lordship. That matter is pending.
Ah.
But here the question is, before your lordship, is whether railway, by way of my lord, executive instruction, levy penalty, my lord, when the power has not been given under the act. Number 1, number 2, your lordship, whether for the same act, my lord, there cannot be twice, penalty can be twice. Whether the full bench of this honorable court in Megha electric technical matter held that before imposition of penalty, an opportunity of being heard should be given against whom penalty is thought to be levied, your lordship. Because, my lord, imposition of penalty is, my lord, quasi-criminal proceeding, your lordship, as held in Hindustan still. Whether that part was taken into consideration or not. 3 or 4, since the matter is pending before division bench, my lord, where rule has been challenged, whereby railway has levied, my lord.
Matter is still pending.
Pending. And that was stated by division bench.
Where is that rule 4?
Rule 4, my lord, your lordship may kindly take up item number 18, my lord. 1/8.
1/8.
1/8, your lord. Mahalakshmi continent.
Is it not available in item 15?
15, I think at that time rule was not there. So subsequently, my lord.
What is the name of the rule?
My lord, railway punitive charge for overloading of wagon rule 2012. It was there,
It is there.
but rule 4 was at that time was not there. Subsequently, they amended it,
Subsequently, that rule was
amended your lordship in the
December, Malad,
in
2012.
12. So
That is there. Rule 4.
rule 4 is
Proviso is Malad amended, Malad.
rule notwithstanding,
Below the proviso.
my lord, below the proviso.
It is there.
It is there. Notwithstanding, anything contained in rule 3, if overloading is detected in the wagon that had gone load adjustment at the consigners either directly or through their designated agencies, punitive charge of rupees 1 lakh per wagon shall be levied. It was challenged before my lord division bench for this rule, my lord, and division bench has been pleased to state the operation of this rule. Your lord. Because
Now-
of challenge, here, your lordship, what the railway has done, my lord, by way of executive instruction, page 33, my lord, if your lordship may kindly take up item number 18, my lord. I
Alright, 18.
prepared item number 18. In all the matters, issue is same. Page 33.
33.
My lord.
Yes.
May I
Yes.
read your lordship?
Hmm.
Ministry of Railway has decided to levy penalty of rupees 5,000 as detention charges per overloaded wagon in case of detention of a rake after women warranting load adjustment at the originating station itself in case of detection of overloading at originating point. Stunting charges for use of railway loco for such adjustments will be continued to be levied as per the extent rule. It was challenged because, my lord, on the ground that, my lord, for detention charges already, my lord, subsection 11 of section 2, your lordship, there is a provision to levy, my lord, demurrage charges. And demurrage charges is in respect of detention of, my lord, wagon, your lordship. And in that context, railway under section 73, they have framed rule and they are charging it. So there cannot be, in addition to what rule has prescribed, your lordship, that cannot be. And here your lordship will see, this is automatic, my lord. The moment they will say that this is overloaded, they will impose penalty at the rate of, my lord, 5,000 per wagon, your lordship. Penalty cannot be automatic, your lordship. That's why in the full bench decision, this honorable court held that before imposition of penalty, an opportunity of being heard should be given to the person against whom penalty is thought to be levied. Number 3, my lord, section 33 empower railway, my lord, to fix rates, but not impose fresh penalty, your lordship. Power under the act is not there to issue such type of, my lord, executive instruction whereby by which, my lord, they will impose penalty, your lordship. Hence, my lord, the railway, this executive instruction is, my lord, without authority of law, and the authority exceeded its jurisdiction while issuing this executive instruction. So far as, my lord, imposition of penalty for detention charge, they have already framed rule, rule 4. And that rule is also under challenge because that rule says that it should be levied per 1 lakh per wagon. This is automatic. That cannot be automatic, your lord, because it is in violation of full bench decision of this honorable
Where is
court.
the full bench decision?
My lord. Before the full bench, my lord, because of the two divergent view taken by two division bench, matter was referred before the full bench, your lordship. In salt marketing and, my lord, in Murli Manohar.
Yes,
In
please carry on.
Paragraph, relevant paragraph, it starts from, my lord,
No, read the whole judgment.
my lord.
Sure.
May I start, your lordship?
Yes.
The railway is empowered to penalize consigners when excess load is detected through reweighment of loaded railway wagon. And the question to be answered by the full bench is whether a focus notice opportunity could be provided to the consignor before punitive charge is levied for excess load. The matter is placed before the full bench on account of divergent view taken by this court in so and so, report in so and so, where a division bench opined that the principles of natural justice must be followed for penalizing a consigner, whereas the counter opinion is expressed in Union of India versus so and so, where it is held that parties to the contract in commercial transactions cannot invoke the writ jurisdiction of the court. It thus declared that the earlier decision in salt marketing was per incurring decision. Division bench, Mr. So and so firstly submits that in case of salt marketing, there was no binding contract between the railway and consignor, and thus penalty charge for excess load was being levied under Section 73 of the Railways Act. On the other hand, the parties were bound by a contract to pay penalty charge for excess weight, and therefore the situations in two cases are projected to be different. It is thus argued that the decision in salt marketing was rendered in the context of facts of that case, and the ratio may not have direct application in the later decision in so and so. Since in the later case, the parties are covered under the contractual obligation, corporate obligation. The Learned Counsel submits that although power to levy penalty charge is conferred under section so and so, when the word may is used in the section, it is discretionary power to be exercised by authority, referring to the provision of rule which is before your lordship. So and so, where the word shall is used, the council argues that a rule cannot override the Railway Act. It is therefore contended that the discretionary power must be exercised in the context of each situation with due opportunity to the affected party. The appellant submits that the consignor is made responsible for the accuracy of the particulars furnished by them in the forwarding note during entrustment of goods to the railway, but there could be factors unrelated to the consignor such as faulty way bridge, defective way bridge, etc. when the accuracy of the declared load in the forwarding note may not match. The council thus questioned that where the consignor is not at fault, should they still be automatically penalized? Mr. So-and-so that argues that the penalizing a party is a quasi-criminal process, and in the event of bona fide mistake, the consignor should not be subjected to punitive charge. By interpreting the powers under Section 73 of the Railways Act to be mandatory, the council therefore argues that the penal provision must not be applied blindly, as the power has to be applied with due discretion in appropriate situation. On the other hand, Mr. So-and-so for the respondent submits that the dishonest intent or relevancy of the consignor is not a relevant factor for levying penalty charges for overloaded wagons, as the objective of the levy is to prevent damage to wagons and the rail track, and accordingly, the council submits that whenever overloading of wagons is detected, the penalty charge must automatically be levied, and providing opportunity in such cases is unnecessary. Since goods were loaded at owner's risk by accepting the consignor's declared weight and concessional rate of tariff was availed by booking the goods at owner's risk, the levy of penalty charge for overloaded wagon is considered to be mandatory and not a matter of discretion. The Railway Council refers to the use of what shall in Rule 3 of the penalty charge rules to argue that levy of penalty charge is not a matter of option, and the penalty of overloaded wagon is mandated by law. In all contingencies where the railway wagon were detected to be overloaded beyond its normal carrying capacity, Mr. So-and-so submits that it will be impractical to issue so-called notice and provide hearing to the consignor before penalty charge is levied, since the penalty amount is to be collected before delivery of consignment under section so-and-so. The senior council therefore contends that if delivery of goods loaded on wagons is put on hold to provide opportunity to the consignor, the railway operation at the place of delivery through blockade of rail track would be severely jeopardized, and it is not at all a viable option. The submission so-and-so. The judgment in a later case can be described as per inquiry decision only when a binding verdict for similar case is ignored by the court. But when decisions are rendered in different factual contexts, the disregarding of the ratio in the earlier case cannot be said to be per inquiry decision. In appropriate and similar circumstances, respect of an earlier judgment should be the norm, but exceptions are permitted in deserving cases where the facts are dissimilar and the parties are governed by different terms. applying the same verdict would result in unequal treatment. Therefore, when a decision is reached on different facts, the provisions, the previous decision cannot be described as per interim decision, where the court is conferred with another situation where the parity of judgment will not be warranted. The circumstances in both cases must be alike, and only then consistency of judicial approach can be expected. But in our considered view, the situation in salt marketing and so were dissimilar, and therefore it was not correct to categorize the earlier judgment as a per interim verdict when the circumstances in the latter case were incompatible. To analyze the issue further, the consignor in the first case, that is so was not covered by any contract with railway, but they are penalized for excess load by invoking section so. Whereas in the case of so, the parties were covered by a commercial contract. In such differential situation, the ratio of the earlier case may not be applicable in the later decision. Since every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generosity of the expressions which may be found there not intended to be exposition of the whole law, but governed,
Okay,
my lord.
yes.
Ultimately, full bench held, my lord, before
Salt
imposing
marketing has been upheld.
upheld.
Yes.
So in that scenario, lordship, particular, my lord, circular has been challenged on the ground that number one, my lord, power has not been given under the act to levy penalty, my lord, 5,000 rupees, as my lord levied by my lord railway by way of executive instruction.
But there is a power for imposition of penalty.
Penalty, your lordship. For that, my lord, rule has been framed and they are imposing penalty, your lordship, as
Hmm.
per rule 3.
Now
So there
this,
cannot
this,
be, my
this
lord,
circular came out when? After the stay of the division bench order? After stay
before,
of the
before,
rules?
before.
Before? So what is this circular? Is it pursuant to the rules or in conflict or what?
Hello, actually, here is the case, my lord, that the so far the judgment is concerned that has been now read, my lord. This is in context with the section 64, railway receipt, and my lord, section 72. Here, my lord, when 73, when punitive charge is imposed, then, my lord, the train is on track, my lord. There is no time. Therefore, in some cases, no notice was given. Directly issued the punitive charge. The Honorable Court said, in such circumstances where punitive charge under section 73 is to impose, then at least one notice is to be given in that context, my lord. And so far, this present case is concerned that notification, my lord, here, Lordship, section 30 of Railway Act give 30 subsection 2 gives power.
No, what we want to know is,
My
you already have a rules.
My lord,
There is
this
a
is
set
for
of rules.
imposition of
Penalty.
penalty. And
Now,
for
why did
that
you,
purpose, notice is to be given.
so then why did you bring this circular?
My lord, circular is for, my lord, while we found that overweight is found, and then it leads to, my lord, it leads to reassessment of the weight, taking help of bridge, way bridge and all, my lord. And for that purpose, lordship, time consumed and other trains suffered. My lord, this is the intention behind. And section 30 within bracket 2, my lord, subsection 2, it says the central government may, by a like order, fix rate of any other charges incidental to or connected with such carriers, including demurrage and welfare for the whole or any part of the railway, and specifically in order the conditions subject to which such rates shall apply. My lord, this is on the basis of section 30 within bracket 2, my lord, that Railway Act, this circular has been issued. My lord, because
It does not reflect in the circular.
my lord, but our instruction is that, my lord, on that basis, my lord, this has been issued.
The circular is for overloading
Overloading and
as per the subject.
my lord.
And if you look into your rules, rule 3 says punitive charges for overload.
Yes, my
So
lord.
there is already a set of rules.
Yes, punitive charges in connection of section 73 and section 62, my lord. Railway 64, railway receipt. My lord, in railway, my lord, what they have done, my lord, in this consignor, they used to give the bundles together, and the railway receipt, there is a provision that as per your verbal commitment, we are keeping this so and so ton, and that will be weight. If weight is more, then you have to pay. In such cases.
Railway Act, no? Railway. Act. Yes.
Wait, over. Section 65, actually, not 65.
Yes.
My
Carry
lord.
on.
My lord, railway receipt is in section 65. Railway receipt says, my lord, it is a prima facie proof that you have given the total weight of the items. In some cases, that as per their oral version, that railway receipt is to be written. And in the station, if it is weight, then if it is found more, section 65, my lord, railway receipt.
Yes.
A railway administration cell, in a case where the goods are to be loaded by a person entrusting such goods on the completion of such loading, or in any other case on acceptance of the goods by it, issue a railway receipt in such form as may be specified by the central government. Number 2, my lord, a railway receipt shall be prima facie evidence of weight and the number of packages stated therein. This is called said to content, my lord. Provided that in the case of consignment in wagoner load or train load, and the weight or the number of packages is not checked, my lord, by a railway servant authorized in its behalf, and a statement to that effect is recorded in such railway receipt by him, the burden of providing the weight or the case may be the number of packages stated therein shall lie on the consignor, or the endorsed thereon. My lord, comments is also important, my lord. Primary fact that the goods in question were entrusted to the railway for carriages must have to be established, notwithstanding the issue of receipt. By other document, my lord, he has to substantiate that he has given this weight, total numbers of package or like, my lord. Otherwise, the railway receipt said to contain what have been said, my lord, this will prevail. Now, imposition of penalty, section 73, my lord. Punitive charge.
Yes.
Where a person loads good in a wagon beyond its permissible carrying capacity, as exhibited under section 2 or subsection 3, or notified under subsection 4 of section 72, the railway administration may, in addition of the freight and other charges, it is in addition, recover from the consignee or the endorsee, as the case may be, charged by way of penalty at such rate as may be prescribed before delivery of goods, provided that it shall be lawful for the railway administration to unload the goods loaded.
Now
beyond
you
the
want to say
capacity.
that the rules of 2012 are made under what provision?
72.
70?
I'm sorry, ma, 73.
73.
Yes, ma.
And the circular?
And my lord, this circular, my lord, it appears it is section 30, subsection 2, my lord.
30.
Yes, 30, my lord. The central government, it started with, my lord, the central government by a like order fix the rate of any other charges incidental to or connected with such carriers, including demurrage. It includes demurrage and warfare, my lord. Any other charges, if there is any, my lord.
No, this is
For-
penalty.
My lord.
This is not charges, this is penalty.
My lord, fixed rate of any other charges. Subsection 2, my lord.
Yes.
Fixed rate of any other charges incidental to or connected with such carriers, including demurrage and warfare. It's above these two charges, my lord, demurrage and warfare of charge.
Hmm.
Fixation of.
Hmm?
This section says about fixation of rates. It
Hmm.
doesn't say to levy, my lord. Here they are
This is-
levying.
By
penalty.
notification, that has been done, my lord.
Charging section is 73 only.
My lord, because the notification para one is the answer, my lord. Let me read again, my lord, notification para one. Ministry of Railway has decided to levy a penalty of 5,000 as detention charge per overloaded wagon in case of detention of wreck. My lord, this is detention of wreck after women warranting load adjustment, where load adjustment has to be there. If there is
See-
load
see,
adjustment,
I-
because if a capacity is, my lord, 50 ton and he bought it 60, then 10 ton has to be removed. And for that purpose, time has to be, my lord, consumed. And this is the idea. And for that purpose, the next train will suffer and there will be congestion in the, my lord, railway
So
station.
what stops you from doing it under the rules?
My lord,
You
it-
already have a set of rules, do it under the rules.
Lord, because our answer is, my lord, section 32 empowers the railway administration for impose if any charges beyond the, my lord, demurrage and the welfare. My lord, this is for that purpose, my lord. This
Rule 4.
So you want to say that penalty is also a charge?
a penalty is a penalty, my lord. Penalty for overloading, he has to, my lord, but there is a procedure prescribed, my lord, that per ton.
No,
That-
no. Your circular says
Yes,
decided to levy a penalty,
my lord.
not charge.
My lord. My lord, actually,
It says penalty.
as detention charge. My lord, this is a charge for detention of the rat
Moreover, rule 4.
and for congestion in the, my lord, station, my lord,
Rule 4.
which has suffered operation of the, my lord, railway.
Rule 4 already prescribed, my lord, for
Okay.
that. Rule 4, you have to kindly see. For the same purpose. Notwithstanding anything contained in Rule 3, if overloading is detected in the wagon that had undergo load adjustment by the consigners, either directly or through their designated
Okay,
agency.
you parties are ready for hearing the matter?
After vacation, lawsuit may fix a date, my lord, for disposal, my lord. In the meantime, if any instruction further required, we will obtain that.
What instructions are necessary to?
For
Only
final
question is
disposal, my
whether
lord.
the writ appeal has been decided or not.
It is still pending, madam. I am
My lord,
appearing
that
in
is why this is also, my lord, bearing division bench order, my lord.
Okay, heard learned counsel for the parties. This challenge in the writ petition is to a circular dated so and so. 16/9/2021, 2011, issued by the railway authorities for levy of penalty on the overloaded wagons.
706.
Stop. Petitioners are agreed. As it is submitted that there is already a set of rules, namely the railways within bracket punitive charges for overloading of wagon bracket close rules 2011, 2012, under which there is a procedure prescribed for levy of punitive charges for overloading of the wagons. Stop. It is further submitted that the particular section, that rule 4 of the said rule, that the validity of rule 4 of the said rules is presently pending before a division bench of this court. Stop. It is further submitted that a full bench of this court in Megha Technical reported in so and so has held that the decision of the Guwahati High Court in Salt Marketing Center reported in so and so will prevail, and accordingly, before imposition of penalty, opportunity of hearing, and the principles of natural justice, opportunity of hearing to be granted to the aggrieved party, and principles of natural justice must be followed before penalizing a consignor. Stop. It is submitted by the learned counsel for the petitioner that the present circular which has been issued and which is issued by the railways and assailed in the present petition is, besides being in conflict with the rules of 2012, is also in conflict with the judgments of this court rendered in Salt Marketing Center, reported in so and so, as well as Mega Technical and Engineers Private Limited. Stop. Per contra, Mr. Das.
BK Das.
Both counsels are appearing.
In a series of matters.
Okay.
I'm appearing on
Different
some
matters.
cases. One case is.
All right. Mr. Das and Mr.
PN Gogoi.
Gogoi appearing for the respondents, oppose the contentions made by the petitioners, and it is submitted that the counter affidavits have been filed and the matter would require some hearing as the notification has been issued as by the railways as being empowered under the provisions of the Railways Act 1989. Stop. Para considering the issues involved and upon perusal of the pleadings on record, this court is of the view that the matter should be heard. These matters should be heard, and an attempt ought to be made for disposal of these matters. Let the matters be listed. Let the matters therefore be listed for hearing on. When do you want it?
Any date, my lord, after vacation?
Also convenience, my lord.
25th.
25th, my lord.
25th January.
My-
List accordingly.
Malad, can it be on another date, Malad? In the first week of February, Malad, second or Malad,
6th of February.
Yes, 6th.
6th of February.
Biplab.
Please, Lordship, with regard to my lord pension of the petitioner, my lord, the provisional pension has been my lord allowed, but main pension, my lord, because of not having of the record of the petitioner with the office of the superintendent police, my lord, the pension could not be materialized.
Yes.
And they are supposed to reconstruct a my lord file in respect of me, my lord, because the entire file has been seized in a connection with the case, my lord, CID case. Though I am not involved in that case, my lord. So due to the my lord record not having with them, my lord, they could not prepare the my lord pension paper, my lord. Forward the my lord pension to the office, my lord, concerned office.
Your date of birth was found to be
Yes,
mismatched.
Lordship, yes,
In the
that's the
affidavit.
thing, Lordship. And whole thing has been, I
That
think we also have,
whatever it is,
produced
I
it
have agreed,
earlier.
my lord. Whatever it is, they have allowed me to retire on that date of birth.
And retirement
and I have
also,
no
Lordship.
grievance.
He was supposed to retire on 31st of January 2020, Lordship, and he retired on June 2020, Lordship. And that apart, Lordship, after construction of the, that means documents, he went for retirement, Lordship. But when he was asked to provide the documents, Lordship, the date of birth was supposed to be 2/2/1960, Lordship. But whereas as per his pension documents, Lordship, His date of birth is shown to be 1st January,
1960.
yes, 1960, Lordship. So due to this, there was some documents, Lordship, mismatch of these documents. So the nothing could be done, Lordship.
No, nothing means he is retired.
He has retired, Lordship. The
Then-
final benefits, Lordship, GIS, DCRG, all these things, Lordship. But this is also of April 23, Lordship. So updated status we require, Lordship, in
No,
this
what is the
matter.
date recorded in his service book?
Service book is 1st January 1960, Lordship.
1960.
Yes, Lordship. And as per his PAN card, it is 2 to 1960, Lordship.
No, so you have recorded some date.
Yes, Lordship. But what is the updated status now, Lordship? Because
This
Your
instruction is,
Lordship, in this instruction on the page 2, paragraph 2, Lordship.
no,
one
madam,
thing is-
this instruction is dated 27/4
Yes, Lordship, yes.
2023.
Yes, Lordship, what I am telling.
So you get your updated
Yes,
instruction
Lordship,
there.
I shall.
Reconstruction জানতাম না।
हाँ. এটা তো পেছৰ বাকলৈহে মেইন লাগিছে।
এতিয়া মোকতো ইনফৰ্ম কৰা নাই নেকি?
সেইটোৱেতো
Third,
কথা।
learned counsel for parties. The petitioner's grievance is that
এতিয়া
although he is superannuated from service after rendering,
পেন কাৰ্ড লৈ আছে।
ডকুমেণ্ট
superannuated from service under the department of so and so, his pensionary benefits have not yet been released.
দিগদাৰ হয়
Fair.
হেৰিবিলাক সেইকাৰণে ৰিলিজ হোৱা নাই।
The respondents have filed their affidavit
বহুত কথা আছে এইটো এদিনে ধৰিব এইটো বস্তু।
wherein it is stated that
বেছি কৰি
the documents received from the petitioner reveal that there is a mismatch with his date of birth reflected in the
মানে খেলি মেলি অলপ হৈছে এদিন ধৰিব।
PAN card and as per the records available with the department. Stop. In that view of the matter, although provisional pension has been granted to him, the final pensionary benefits have not yet been released. Para. M.S. Bhattacharjee, learned additional senior government advocate, will apprise the court as to the steps taken by the petitioner, by the respondents to finalize the pension papers of the petitioners and release all retiral dues and benefits payable to the petitioner. List on.
First week of February, Lordship.
5th of February.
Yes, Lordship.
I love it.
Yes, Mr. Ali.
In the last occasion, my lord, it was sought for my lord from the department.
Where's department?
They took time, my lord.
My lord, we need more time, your lordship. We
But
didn't
pension
still
matter, we
receive
are
the
retired
instructions, your
teacher,
lordship.
my lord.
No, more time is okay, but you must get your instructions here.
2020.
Different councils appear on different dates and seek for time. You do one thing, you call Mr. Chisti if he is available. He has been appearing in this matter. Is he available in
Yes,
court?
your lordship.
Please ask him to come at 2 p.m. Let's find out what is the
He's
status.
here, your lordship. I may be allowed to call him, your lordship.
Call him. After some time. Yes.
My lord, before my learned senior from the other side starts, I have a small prayer, my lord. Mr. B. Chaudhary, Standing Council, Finance and Taxation Department, has some inconvenience today. Let my learned senior from the other side make his submission today. I shall note it down, my lord.
Yes. Can we take it up in the second half, subject to your convenience?
Thank you.
So then we can complete up the other matters. Say around 2:30, 2:30, 2:45.
Shall you oblige, my lord?
May I please, your lord?
Lordship, before my seniors class, Lordship, may I pray for adjournment or for Lordship final disposal on any other date. Mr. K. Gogoi will lead, is leading in this matter, Lordship, and he is on legs, Lordship. Any other date, Lordship, may it for final disposal. Because
What is the issue here?
Issue, your lordship, the petitioners, your lordship, who were appointed, your lordship, as assistant professors, your lordship, in two engineering colleges, your lordship, the Jorhat Institute of Science and Technology and Vinasar Brahma Engineering College. When these schools, the colleges were taken over by the government, their seniority as well as the salary, your lordship, was refixed, your lordship, to their prejudice, your lordship. That's the case, your lord. Whether the authority can do that or not, your lord. That's an issue, your lord. And in fact, your lordship, we became juniors to these teachers who were appointed after our appointment, your lord. Much after our appointment, your lord. Our seniority in service has gone, your lordship. So far as the salary is concerned, your lordship, that has been reduced, your lordship. On the ground that they have regularized our service by taking over, your lordship, from the society mode to government mode. Your lordship.
All right, then give us a date.
First of February, your lordship. Thursday.
1st of February. A joint request matters are deferred to be listed on 1st of February.
Your lordship may record that
An attempt will be made to hear and dispose of the matters on the next date fixed.
Deeply obliged.
None appears. Passed over. You are appearing?
Yes, ma'am. But in this case, my lord, PWD has filed an affidavit, my lord. I have to file a reply, my lord. Please,
Mr. S. Mukhtar, learned counsel for the petitioner, submits that he'd like to file a rejoinder affidavit to the affidavit filed by the petitioner.
PWD.
By the PWD department. He prays for 3 weeks' time. And Mr. A. Hassan appears for the Accountant General. Mr. R. Borpujari for Finance. Who's for PWD?
P. Nayak appears, sir. P. Nayak appears.
Huh?
P. Nayak appears, sir.
Mr. P. Nayak for PWD. Yeah.
Obliged.
Yes.
Lordship, there were some instructions to the respondent on last
Sorry?
occasion. There were some instructions to the respondents on last occasion.
Yes, respondents, what instructions?
To produce the relevant rules under which the service of the petitioner's husband has been ceased, your lordship.
The records were also sought, your lordship.
He expired. Husband expired.
Husband expired, your lordship. There are two aspects in this case, Your Lordship.
Hmm.
Firstly is that the petitioner, husband has joined the service in the year 1985 and has served in the bank till 2002, Your Lordship. After that, he was unauthorized. He was under unauthorized absence, and in the year 2016, he expired. Now the petitioner is before this honorable court claiming the terminal benefits and pension. Regarding the terminal benefits, Your Lordship, the PFM gratuity has been paid. And regarding the pension part, Your Lordship, the petitioner has completed from 1985 till 2002. His service is 17 years. And for pensionable, eligible pensionable service, it is 20 years as per the bank rules, Your Lordship. And I have flag marked the relevant portion under which he was placed under voluntary retirement for his unauthorized absence.
Did you serve any notice?
Yes, Your Lordship, it is annexed in our affidavit in opposition. Page 40 is the first notice. Subsequently, we have issued notice on 15/5/2002. And the last notice was 13/6/2002, Your Lordship.
Where do you find this period of service required for pension?
That part, Your Lordship, I have mentioned in our affidavit in application also in page
Yes,
28.
have you gone through the rules?
Lordship, yes, and I have also categorically replied to whatever he has stated in his affidavit in opposition, Your Lordship. So I would kindly request you to go through the affidavit in reply, Your Lordship.
Kindly take us through the affidavit in reply.
May I read the relevant portions, Your Lordship?
Yes, yes.
Paragraph 4, that with regard to the statement made in paragraph 4 of the affidavit in opposition, the deponent begs to state that there is nothing contradictory in her writ petition regarding employment of her deceased husband in the State Bank of India at Dibrugarh, and it is unfortunate that the respondent, instead of straightway admitting the fact of her deceased husband employment in their bank, trying to dilute the matter mere on some technical point, whereas his employment in SBI is not denied by them. It is to be mentioned here that nowhere the petitioner tried to hide the fact that her deceased husband could not perform his function in the bank after 2002 due to his illness, and so far the notices sent to him, which now appears from the affidavit, it seems that once notice was sent in 1995, after which no notice till 2001, first part of the year, and after 1 year in 2002. So he could not be deemed irregular during this period because the duration between the first notice and the second notice is a huge duration, Your Lordship.
Why was he not in service? For
Your
what
Lordship.
purpose?
Your Lordship.
Why could he not attend his services?
Your Lordship, he was very much after getting the first notice, he again joined the service, went regularly. Kindly see, Your Lordship, first notice was sent in 1995.
Where is that notice?
We have annexed it, Your Lordship, in our affidavit in opposition.
And the second one, after a long period, that is 2001, Your Lordship.
No. He was shown to be not attending to his services.
Yes, Your Lordship.
Do you deny that?
Your Lordship, after getting the first notice, he again joined his services regularly. And that's why between 1995 and 2001, there was no action, no notice, nothing, Your Lordship. because he was very much regular during those period, Your Lordship.
What documents, do you have any documents to say that he had joined in his service?
Your Lordship, because if I would not have been in my service, I would have been, they would have taken some actions against me, Your Lordship. But from 1995 to 2001, no notice, Your Lordship, no action, because I was very much regular, Your Lordship. And that's why they were told to produce the reports which they have not brought till date, Your Lordship.
No, Lordship, we are petition has been filed.
And they're pleased that they will produce the reports and he is absent and all that, Your Lordship. But thing is that if the records are not available with them, then on what basis they have calculated the PF and the gratuity of the deceased employee, Your Lordship? They must be in possession of some documents, otherwise how they can do this? They cannot do this in haywire, Your Lordship.
Yes.
Lordship, in the writ petition itself,
And even Your Lordship, the voluntary retirement benefit should be given if he is in service for 15 years. So even if suppose it is presumed that he is only entitled to voluntary retirement benefits, that is also not paid to me, Your Lordship, till date. And Your Lordship, so far their own rules are concerned, if an employee renders 10 years of service and he is on service on and before, that is, if Your Lordship allow me, I would like to.
No, from 2001, come to page number 38, that enclosure of in the affidavit.
Page number, Your Lordship.
Continuous paging 38. Which is the
Yes, Your Lordship.
now, this is a notice for unauthorized absence
Yes, Your Lordship.
issued in 2001.
Yes, Your Lordship.
Then next page is the another memorandum issued in 2002,
Yes, Your Lordship.
where he was deemed to be voluntarily retired.
Yes, Your Lordship.
So for 1 year, he did not attend his services.
Your Lordship, because he is given only 7 days to appear, Your Lordship.
No. 2001, he was put to notice that he was not in service,
Yes, Your Lordship.
which means that although there is no date mentioned here, but some days, some months, he was not in service prior to 1/3/2001.
That may be, Your Lordship.
No. Maybe you are the legal heir.
Your Lordship.
Then finally on 9/1/2002, he was deemed to have voluntarily retired. So at least for a period of almost 1 year, there appears to be that he was not in service. Where was he?
Your Lordship, because their own notice, that is 1/3/2001.
Ah.
There on last paragraph, Your Lordship. I again advise you to report for duty within 7 days from the date of this letter, failing which disciplinary action will be initiated against you. Your Lordship, 7 days. That is given on 1/3/2001. Then why they were silent for more than 1 year?
No. Why they were silent, we'll come to it later. You tell us, where were you? Where was your husband?
I was at service. That's why they have not taken any action against me, Your Lordship.
Oh.
Because if I'm irregular for even 1 month, they can give me such a notice, Your Lordship.
So you mean to say because no notice was given, he was in service?
Yes, Your Lordship.
Oh, he was receiving salary.
Yes, Your Lordship.
Can you show us from the bank statements?
Your Lordship, because I in my petition already I have stated that all my documents were burned in
Burned?
fire. Yes, Your Lordship, because I was in a rental house and it was burned. And
Now, what do you want from the court?
Your Lordship,
What do you want from the court?
Your Lordship, superannuation benefit, Your Lordship.
Superannuation benefits.
If your lordship allow me, I would like to place one of the judgment of the.
Your documents may have been burned, but
Yes, your lordship.
assuming your husband probably have maintained some account in the bank
Your lordship,
for getting the salary.
I could only give the PF number, your lordship. And on the basis of which they have given me the gratuity and provident fund benefit, your lordship.
His salary is released how? In cash or in the account?
In the account, your lordship.
In the account.
In the account, your lordship.
You find out from the bank account. Get the details. When was the last salary received?
The writ petition, page number 4.
Huh.
The very beginning, paragraph 3, your lordship.
Yes.
That the husband of the petitioner served in the capacity of a messenger in the State Bank of India from 1985 to 2002.
Where?
Writ petition, page number 4, paragraph number 3.
Yes.
That the husband of the petitioner served in the capacity of a messenger in the State Bank of India from 1985 to 2002.
So that is a
Admitted fact, your lordship, that till 2002 he was in service.
Huh.
In our affidavit in opposition, page 40, your lordship, he was absent from duty. Last he is present is 17/4/2002, your lordship. Thereafter, he was not. He has not reported back to the duty, your lordship. Only on the 17/4/2002.
17/4/2002.
Yes, page 40 of my affidavit in opposition.
Then why did you issue this 9/1/2002 notice?
In earlier occasion also he was absent. That was with regard to that aspect, your lordship. But the voluntary cessation was done only because he was absent from 17/4/2002 till 2016, your lordship.
Your lordship, I have also admitted that in my petition that I have not gone to service from 2002, your lordship. Nowhere I have denied that, your lordship.
So the PF and gratuity you are entitled in such a case, and we have released the PF and gratuity. But regarding the pension, your lordship, 20 years of service is required for pension.
Where is that rule? Where is the rule?
That is the general rule, your lordship, but there are certain conditions. Even when if an employee gives 10 years of service, then also he can be given superannuation benefit if he fulfills certain conditions, your lordship. I can give your lordship one of the judgment of the Honorable Supreme Court, your lordship.
You first show us from the rules. Judgments will go into, but show us from the
Yes, your
rules.
lordship. The rules is also discussed in the judgment, your lordship. That's why.
The SBI does not have the facility to furnish copies to the court.
No, lordship, I am having. We have mentioned it in the.
You are the mighty SBI. You are appearing, defending the SBI with one set of rules circulating around. Yes, or you don't want the court to go through your rules properly.
28, your
Perhaps.
lordship.
Yes. 20?
No, it is written in the rule 22, your lordship.
22.
1.
Yes.
After having completed 20 years pensionable service, provided that he has attained the age of 50 years, or he is in service of the bank on or after 93, after having completed 10 years pensionable service, provided he has attained the age of 58 years. Had he been joined after 1/11/1993, 10 years service would have amount to his pension.
When did he join service?
1985, lordship.
85.
So, lordship. That means he was in service during this period, your lordship, 1/11/1993.
You are interpreting the rule that if he had joined service on 1/11/93. Is that what you are interpreting?
No, he has joined in 1985, and if employees.
No. When did he join? 85.
85, lordship.
85. And retired in or deemed to be
2002, lordship.
2002.
So it amounts to 17 years. Your lordship.
17 years. So why is it not covered under clause B?
Lordship.
Clause B of the rules? Rule 22, clause B?
93 years. Because he have joined prior to 1985, 1993.
That is what we are trying to understand.
Lordship.
The rule does not. Do you have a copy of the rules with you?
No, Lordship.
No. You make a copy,
Lordship.
Your Lordship, allow me, I would like to place one of the judgment of the Honorable Supreme Court.
we'll come to the judgment, madam. First, let us understand the rules.
The rule is also interpreted in this judgment, Your Lordship.
So why can't you refer to the rules first? You make a copy of the rules, address the court on the rules, then you say us what is the judgment says.
Yes, Your Lordship.
You make a copy of the rules, bring it at 2 o'clock.
Lordship.
You share a copy with the counsel for the petitioner also. At 2 p.m.
Obliged to you.
Yes,
No, the department was supposed to produce the record.
records.
Yes, ma'am. As regard on the basis of which that order dated 2022 was passed, Lordship. I've received the record, Lordship. It is a very interesting case, my lord. The petitioner, he was suspended with the conditional approval of the higher authority. And it was continued for long 10 years. After that, my lord, he was reinstated, but without any approval and without regularizing his service, this suspension period.
No, first tell us the dates. When was he suspended?
He was suspended, my lord, on my lord, suspended on, my lord, 2011, my lord. Suspend 13/7/2011, my lord.
2011.
Yes, my lord.
Then what happened?
Then it is, my lord, SOCOS was issued to me for 2 times. I given the reply. Subsequently, my lord, DP was constituted. I was asked to appear. I participated in the departmental proceeding. Nothing was found against me. Rather, they advised that I was suspended for a long period of 8 years more, so I should be reinstated. That was my lord. After that, my lord, they have reinstated me after 10 years. And without regularizing my suspension period, then I approached before a lordship. Then they regularized my suspension period. But the remaining, my lord, the penalty that was imposed in dealing my lord, my suspension period with the 1 year stopping of increment with cumulative effect, that was not returned, my lord. And as so far the inquiry report is there is nothing is found against me. That is, my lord, very interesting. From where they specifically admitted in this impugn order that on the basis of the inquiry report, but inquiry report is totally silent that about anything was found against me.
Lordship
And my person is at the verge of retirement. He is going to retire in this year.
Lordship will find the inquiry report at page 49, Lordship.
The records.
Of the records, Lordship.
Yes.
Page 49 is this order of 2/2022 was passed on the basis of the inquiry report and the report of the district elementary education officer. And the inquiry report, your Lordship will find at page number 49, Lordship. No, Lordship, record.
49.
49. There is a flag mark.
And
Yes.
therefore,
He has been reinstated only that one stoppage of increment, Lordship. That is there.
Okay, then
Then, Lordship, there is another report from the district elementary education officer. Lordship will find.
no, but where is the
Subsequently, on the basis.
no, Mr. Sarma, this is the inquiry report. Where are the inquiry proceedings?
But only report, just now I received that record, Lordship. I couldn't go through entirely, although the inquiry report.
and the inquiry also, my lord, is a violation of Rule 9 of 2 of the discipline appeal rule, my lord.
He kept it in the suspension for 8 years.
Yes, more than 8 years, my lord.
8 years, 3
3 months.
months.
Lordship.
And the approval, without approval, I was put on the suspension, my lord. If it is no approval, then suspension was not effective, my lord. This is my submission also in other end. Because condition was there with the approval of the higher authority. Approval is not, higher authority is not there. So with approval is not there, then where is the suspension, my lord?
To be fair, lordship, that approval was not there.
Entire act is well all before the card.
Lordship
The
will find that
approval came after the reinstatement.
lordship approval is there in page number 61.
After reinstatement, my lord.
I must submit fairly.
Very
lordship.
surprised, my lord. This is how this thing happened in the department concerned.
Where is that approval?
Page number 61, lordship.
61.
In my repetition, my lord, this is a 50, my lord.
Subsequently, it was approved. Lord.
In 2021.
2021, Lord. Perhaps in order to regularize those suspension.
I was
but then,
my
to be
service
very
was
fair,
regularized,
lordship,
everything was regularized before that, and my approval was done later on. And by this last order, this is my repetition, my lord, page number 50, by which they regularized the entire period, but so far the penalty that was imposed,
and
that was remaining same, but they dropped the, my lord, departmental proceeding.
the report of
last
the
order.
DEO, lordship will find at page number 97. The report of the DEO,
97.
97. On the basis of which this order of 2/2022 has been passed. One of the report. Now the issue remains only for that stoppage of one increment.
With cumulative effect. That will hamper my entire gratuity and under my all, my lord, retirement benefit.
Now, what is your position? You have retired.
No, I am not retired. I am working, my lord, but
Okay.
at the base of the retirement, after 7 months or 8 months, but I will be retired. I mean, it is there, my lord, that my entire pensionary benefit will be affected. And they have conducted the inquiry. That is in violation of Rule 9(1), 9(2), and 6 also, my lord.
What is the violation?
My lord, they did not furnish any, my lord, documents on which they relied. Neither
That is
they.
what we wanted to see. Where is the proceedings?
Yes, my lord. That is,
Where
I
is the
have annexed, my lord,
proceedings?
the copy of the, my lord, that is annexed 10 at page 39, 34, 39, my lord. This is the report, whatever I subsequently procured.
The report is available here. You are referring to the report of the district elementary officer.
This is an inquiry report, my lord.
Inquiry
District
report
elementary
is
officer.
Ah,
Yes. Inquiry report to Sri Ajit Kumar under suspension, junior assistant of the.
dated 20th December 2021. Which report are you referring to?
21/11/2019. That inquiry report, lords.
Inquiry report is it?
49 in my record,
49.
page 49.
But the proceedings are not here.
Lordship,
What kind of a report is this?
lordship.
Careful observation of the available. Where is the available evidence?
Nothing is there. What are the document they relied?
Then what
are the-
kind of a committee is this? It's not an inquiry officer.
No, no, inquiry officer.
Then it says committee.
One is the inquiry officer.
Bani Bhattakur, she was the inquiry officer.
Inquiry officer is Bani Bhattakur.
She also retired from service.
submission, the entire process is vitiated with law, my lord.
What is annexure 10 in the writ petition?
This is, my lord, the inquiry report, my lord. Page number 39.
This is a document from which Mr. Sharma?
Lordship,
Where is this document? Page number 40,
page number 40.
40 capital A.
Lordship, the next one, page number 50. This is a forwarding letter, Lordship.
Forwarding letter.
Lordship. 40A is the forwarding letter of the inquiry report. The next page.
This was a forwarding, my lord.
Yes.
40 is the type copy and 40A is the, my lord, original one.
But the proceedings are not here.
Lordship, that record is not there.
The inquiry findings are here.
Findings are there, Lord.
Mr. Mohanto,
My lord.
the inquiry findings are here. Where on the basis of the evidence,
Is it the same copy, my lord, whatever I annexed, my lord?
yes, yes.
This
That
is-
copy,
that-
that
that-
copy
that
is
That is
the,
the same copy, my lord.
huh?
Same copy, my lord.
No, you are referring to Annexure 10.
Yes, my lord.
Annexure 10 is the forwarding letter.
No, annexure 10 is 39 page, my lord. This is the inquiry report. That was submitted by the inquiry officer Bani Borthakur, my lord.
There is a forwarding letter.
No, this is inquiry report.
Inquiry report. Yeah.
Then forwarding is in next page, my lord.
Yes, this is the same thing available.
Yes, my lord.
But the proceedings are not there. That is what we want to find out, how the inquiry was conducted.
Lordship, even I couldn't go through the record entirely, Lordship. Lordship will fix up sometime after the whole Lordship will.
My lord, otherwise, my lord, whatever is there in inquiry, but the entire proceeding, my lord, that is vitiated. And my suspension period also, that is also not as per the
What has happened to the suspension period?
suspension period, that is regular.
Regularized.
Regularized. You have received your,
Yes, after filing the first one writ petition, that was my subsequently with the effect of this reinstatement and the
so
regularized. that was my-
therefore, your prayer at page 25 for
Yes.
release of entire salary for the period of suspension
Yes, my lord.
Lordship, page.
is not required to be pressed.
It is not required to be pressed, but the thing is that so far my punishment is there, my lord.
Right.
That is, I want to that be withdrawn because there is no findings, nothing is there, and whatever is done is a perfunctory. It is without any giving any opportunity.
Okay,
Violating the ninth-
Mr. Sharma, go through the records and point out. If not there, then you call for the proceedings of the inquiry.
Lordship, Lordship.
Heard learned counsel for the parties in terms of the earlier order dated 16/5/2023. The Standing Council Elementary Education, Mr. P.N. Sharma, has produced before the court the records which contain the records pertaining to
findings.
the suspension of the petitioner. What is the file number?
File number is there, Lordship.
In top of the, I
On
think.
top of the file, there is a tag mark.
Contained in file number ECA -10/2019. Stop. From the records, Mr. Sharma had pointed out the inquiry, the findings of the inquiry committee or inquiry officer, as well as the from the inquiry findings of the inquiry officer. Stop. What is also seen from the record is that the approval for the suspension of the petitioner was given on
Approval was on my lord, page 61, Lord.
61.
61 of the record.
On 23rd of August 2021
21.
by the director. Stop. However, pursuant to the inquiry conducted, the petitioner was reinstated in service and a penalty of stoppage of 1 increment was imposed. Stop. However, the records do not contain the inquiry proceedings to reflect as to how the inquiry was conducted, as the entire inquiry proceedings are being put to challenge in the present writ petition by the petitioner. Stop. Vera. Mr. P. Mohanto submits that pursuant to the inquiry conducted, the petitioner's period of service under suspension has been regularized, and therefore it does not wish to press the prayers made in the writ petition for release of entire salary during the suspension period. However, his challenge in respect of the conduct of the inquiry proceedings is being pressed by the petitioner. Stop. Under such circumstances, the respondent counsel will produce the relevant files to place before the court the inquiry proceedings conducted by the inquiry officer, pursuant to which the penalty or imposition of stoppage of 1 increment was imposed.
My lord, one sorted may be given and one more, my lord.
After
My lord, so far, my lord, the reinstatement is there, my lord. This is subsequent, my lord, regularization is subsequent to the, my lord, reinstatement, my lord.
No, now it is treated to be a period on duty. You have got back your financial benefits.
Yes, sir. But the thing
Now,
is that
what do you want to challenge?
because entire act also, my lord, they are visited. I am entire writ petition also on that issue, my lord. This entire process is, my lord, visited because they are putting the card
Process
before the
of
odds, my lord. This is the thing.
that has become infructuous today.
Yes, yes.
Then
That is the matter.
that we have recorded it.
Suspension itself was infructuous.
Infructuous today.
Must have been.
Yes. List on
after vacation.
6th of no, 5th of February.
Lord,
5th of February. Must. No.
Please, Your Lordship. My Lord, my family pension was not revived. And during pendency of this case, my Lord, on the August 2023, the bank authority revised the calculation, but that was wrong calculation has been done. So instead of taking factor 2.48, they have taken 2.14. So I'll have to require a file additional affidavit showing that the calculation was wrong.
You want to file additional affidavit?
Yes, because they have taken wrong section.
All right. Additional or rejoinder?
Additional. They have not filed it.
You have not filed your affidavits.
No.
My lord, your lordship, I am handing over this, my lord, where your lordship will find the arrear amount of.
No, we are only asking you whether you want to file your counter or not.
My lord, possibly I thought the arrear amount has been paid. Now
He
they are
says
saying.
it is not being paid.
Arrear amount paid.
Now,
But wrong-
arrear amount has been paid.
Wrong calculation.
Wrong section.
Let them show that what is the wrong so
All
that I
right,
can
Mr.
take instruction.
S.K. Ghosh, learned counsel for the petitioner, praised for and is granted 3 weeks time to file an additional affidavit to bring on record materials to substantiate his argument, his contentions that the arrear pension, is it?
Not area, for fixation of pension.
Uh,
From the very first month.
To substantiate his argument that the wrong fixation has been done by the respondent department is a bank,
Bank.
respondent bank, while releasing his pensionary benefits. stock.
Area pension.
He is submitted that he is entitled to refixation of the rate for release of his pension. Stop. Mr. Dotto appears, senior counsel appears for the respondent bank. List again on, give a date after 3 weeks.
Obliged.
Your Lordship. For the petitioner, this item may be passed over, Lordship, because the
Request of the learned counsel, matter stands passed over for the week.
and also 42 same prayer.
42, all right.
Obliged.
Lordship, in item 40, Lordship, Lordship, SSA is supposed to file affidavit in opposition, Lordship.
Is there any interim order? Is there any interim order?
Yes, Lordship.
Some interim. There is a private respondent too, my lord.
Lordship, I am.
So, my lord, can it be immediately after the petition? I will file.
You have filed your affidavit, no?
No, it's ready, my lord, we'll file. That is what I.
All right. In item 40, Mr. B. Gogoi, learned standing counsel, finance,
No, it is SSA.
SSA, submits that the affidavit is ready and will be filed shortly.
Lord.
He therefore prays for a date, some accommodation.
First week of
Let the
February.
matter be listed on 7th of February. 7th of February. Item 42 passed over. Yes.
Lordship, the grievance of the instant case is that the petitioner has been illegally not paid her salary from the year 2014 till her retirement.
Salary.
Salary.
Yes. Who's for the respondent?
Lordship, I am for the Social Welfare Department, Lordship. I am
CDPO.
here.
Yes.
CDPO, Lordship. And
She's still working.
no, Lordship. She
Retired.
has went for retirement in 2020, Lordship. Retirement benefit has not been paid. Lordship, most probably they have not served the extra copies, Lordship. That's why no steps could be taken.
We have taken step on 10/3/2022.
Have you served extra copies?
Yes, Lordship.
10/3, it was listed on 33. No, nothing is there.
The learned counsel for the petitioner will furnish extra copies on the respondent counsel to enable them to complete their instructions. M.S. M. Bhattacharya, learned additional senior government advocate, prays for 3 weeks' time to complete her instructions. List the matter again after 3 weeks. You serve copies.
Deputy Ambassador.
Ma'am, please. My lord, this case, my lord, the petitioner got record on 31/10/20, my lord. His pensionary benefits has not been settled on the pretext of some cases, my lord, which they have filed there in their affidavit opposition. But now, my lord, that case has come to the finality, my lord. If your lordship permit me, I can, and don't please.
My lord, the case has been disposed of, my lord. We have recorded in our affidavit opposition also that the final pension has not been paid, provisional pension and all other benefits have been paid.
No,
Final
nothing
pen-
has been paid, my lord. Nothing has been paid to me, my lord.
Lord,
Because,
There
my
is,
lord,
there was, on the last date, there was a submission made that there is some writ appeal pending.
My lord,
That has been disposed of.
my lord, there's a writ appeal has already been disposed of.
Writ
And
petition
it was
also
sent back to
disposed.
the single bench. That matter has also been disposed of, my lord. And my lord, in the writ petition itself, they stated that pension has not been received except for provident fund and GIS amount which they have received.
So what are you planning to do?
My lord, pension can be provided, my lord. We have no issue because the
There is no question of can be.
my lord, your lordship may direct. My lord may come to the affidavit in opposition, my lord, that has been filed.
Yes.
My lord, page number, para number 2, my lord, para number 4, my lord. That the deponent begs to submit that the petitioner was retired from
No, we
service
are
on-
asking you why the final pension has not been released.
My lord, because of the pendency of the writ petition, my lord.
And when was it disposed of?
My lord, in the month,
It has been dismissed, my lord.
it has been on 2023, my lord.
So what has been done after that?
My lord, his services was challenged by another person.
We are
It has
asking
been-
you because you see, when you appear before the court, please check up the last orders. Last order reflects
My
that
lord.
pension has not been paid because of the pendency of the writ
Pendency.
appeal.
Now since the writ petition has been closed, my lord.
This order was
pension can be-
recorded in 13 May.
My lord,
Subsequently, in
The
September, the petitions have been disposed of.
my lord, my lord.
So till now, January, what have you done? That is what we want to know.
My lord, on that I'll have to take updated instructions, my lord. Otherwise, the writ petition can be closed also, my lord.
What do you mean closed? You have not released his pension. How can it be closed?
My lord, with the direction to release the pension.
What do you mean direction? You get your instructions.
My lord, may I pray one thing, my lord, since it is a pension matter and I am very sick also at this moment, my lord. I had a telephonic discussion yesterday, my lord. Lordship can dispose of the writ petition, my lord, directing them, my lord, to make immediate payment to the petitioner, all the benefits, including pension benefit. Because, my lord, on the earlier pretext, my lord, they have taken on the pendency of the writ petition and writ appeal. Both writ appeal has been disposed of, remanding back the writ petition. Writ petition got dismissed, my lord. So now, my lord, in the light of that, my lord, the pensionary benefit cannot be withheld, my lord.
So then this matter will have to be heard on this ground. You are asking us to dispose of a matter with a direction.
It's 2020, my lord.
Maybe, but we'll have to hear the matter and pass an effective order.
Then I'm leaving up to your lordship. Lordship fix a date, my lord. Specific instruction.
List
my
on
lord.
6th of February.
My lord, I'll take
Or by which date the respondent councils will obtain specific instructions as to why the pension payable to the petitioner has not been released, as it is submitted at the bar that the writ appeal number 253 of 2013, as well as the writ petition being WPC number 997 of 2010, questioning the service of the petitioner, has been disposed of.
Dismissed.
Dismissed or disposed of. What about the writ appeal?
Writ appeal remanded back to the.
So writ appeal disposed of and writ petition dismissed. The respondents will apprise this court as with regard to the release of the pension
And
payable
other
to the
benefits also,
petitioner,
ma'am.
inasmuch as per the last order dated 13/5/2022, the matter was deferred on a submission made by the junior government advocate that regular pension is not being paid to the petitioner due to pendency of the writ appeal number 253 of 2013, which is in respect of termination of the service of the petitioner. List again on 6th.
My lord, pensionary benefit along with other benefits.
All right, pension and other retirement benefits. Mr. A. Hassan for Accountant General.
My instruction is as on date, we have not received any proposal from the department.
A. Hassan for Accountant General submits that till date, no proposal for release of pension for the petitioner has been received by the department from the administrative department. List on 6th.
Here I pray for some further time to have the instruction.
All right.
I'll file my affidavit, my lord.
Mr. B. Gogoi, learned counsel appearing
SSA.
for the
SSA.
SSA, submits that instructions are complete, you'd like to file the affidavit. Mr. M.J. Kadir, learned counsel for the
No,
petition.
instruction is awaited, my lord.
Then why did you say you will file your affidavit?
No, instruction is awaited. I will file the affidavit when I get it, my lord. In the meantime, I can file it.
Is of August, my lord,
You have been given sufficient time.
16/8, my lord.
But today, my lord, they informed that, my lord, some further time will be required.
Prays for further time to complete his instructions. Mr. M.J. Kadir, learned counsel for the petitioner, submits that sufficient opportunities have been granted, but the petitioners, the respondents have not filed any counter affidavit. Para. Mr. Gogoi, learned standing counsel SSA, is permitted to complete his instructions, failing which on the next date fixed, attempt will be made to dispose of the writ petition on the basis of the pleadings available on record. List on 13th February.
Obliged, my lord.
My lordship, time over for timing, possible for timing, my lord.
Timing.
Timing.
My lord, we are yet to receive the instructions.
My lord.
Matter stands deferred at the request of learned standing counsel, who submits that further time is necessary to complete the instructions. Mr. So-and-so, learned counsel. You're Mr.
R. Borua.
R. Borua.
On behalf of 8 account.
The counsel for the petitioner does not object. List again after 3 weeks.
Deeply obliged.
None appears, passed over.
Lord,
Mr. Upadhyay, MS so-and-so, and so-and-so appears for the respondents. Give your
Lord.
names.
Lord.
Yes.
Lordship, pertains to his deserted from service, your lordship. That's why he was dismissed from service.
None appears for the petitioner. Mr. D.J. Das, learned CGC, appears for the respondent.
Lordship, we were about to mention, Lordship, maybe a joint prayer. Lordship.
Huh?
Maybe a joint prayer, Lordship. They were about to mention the matter, actually, Lordship.
We don't know.
Much of it.
Yes,
He's here, Lord.
6 weeks time may be granted to file with my lord.
3 weeks.
Not.
All right. Matter stands deferred at the request of Mr. Ovildar, learned counsel for the petitioner, who prays for 3 weeks' time to file rejoinder to the affidavit filed by the respondents. Mr. D.J. Das, learned CGC, appears for the respondents.
Much of it.
To be listed after 3 weeks.
Obliged, lord.
Please, your lordship. Lordship, there is an order passed by this honorable court in a connected contempt petition, lordship, wherein it was directed to be listed along with WPC, 2 other WPCs and 3 other contempt petitions. That is order is there. Only one is listed, lordship.
Just no, madam. Main के कितनी होता है? एक नंबर तो नहीं तो पूरा अपने हमारी वो करने जो तो एविडेंस नहीं तो इसलिए एविडेंस तो काम है तो वादा अच्छा क्या आरंभ कोई से नहीं
The lordship may fix the matter with other 2 read petitions and the contempt petition.
It is submitted by the learned counsel for the petitioner that by order dated 6/12/2023, passed in contempt case number 418 of 2023. The contempt petition was directed to be listed along with WPC 4143 of 2022, 4348 of 2022, and WPC 4110 of 2022. Stop. In that view of the matter, let this writ petition be listed again along with WPC 4143 of 2022, 43484 of 2022, and contempt petition number 418 of 2023.
Lordship, two other contempt petitions were also there, 419 of 2023 and 420 of 2023.
Along with 419 and
420. I have highlighted it.
420 of 2023. Mr. CKS Borua appears for the respondents. All the respondents. List after 3 weeks.
No service.
Your Lordship.
Yes. Yes.
See the order, last order 25/8/2023.
Affidavit not filed.
May I please, Your Lordship? In this matter, Additional Advocate General K. Kaur was to appear, Lordship. Due to some personal difficulty, he could not come, Lordship.
No, that is okay, but additional affidavit has not been filed. I'm sorry, the affidavit has not been filed.
Lordship.
Then, have you seen the last order?
Yes, Lordship.
Why affidavit has not been filed?
Lordship, kindly grant 3 weeks more time, Lordship.
It is submitted on behalf of the respondents that affidavit that Mr. K. Kaur, additional AG, is to appear in the matter. However, he is not available today. Stop. Further time is sought for to file the affidavit in the matter. Stop. As per the earlier order dated 25/8/2023, this court permitted 3 weeks time to the respondents to file their affidavit, failing which it was directed that the court will consider to pass consequential orders on the respondents as notices in the matter was issued as far back as 21/9/2022. Stop. Considering the prayer made by the respondents and the last order dated so and so passed, petitioners are permitted. How much time you require?
After view, Lordship.
After you give us a time,
2 weeks, Lordship.
2 weeks further time to file their affidavit, subject to payment of cost of rupees
Lordship.
3,000 by the respondents.
3 weeks, Lordship.
3 weeks, then 5,000. 3 weeks at the payment of cost of rupees 3,000 to be deposited to the High Court Legal Services Authority. The filing section will accept the affidavit if filed upon proof of payment of the cost as directed by the court. Mr. A.J. Atia, Learned Counsel, appears for the petitioner. Anything more to submit? All right. List after 3 weeks.
Lordship, kindly peruse the order 23/6.
Lordship, here I require some time, Lordship. May fix the matter immediately after the leave vacation, Lordship. Instruction is awaited, although the director has sought for the report from the district elementary education officer.
See, when you make your prayers, you have to make your prayers with effectively. You are asking for to be listed after Bihu vacation. And the offices are going to be closed in Bihu. So who will give you the instructions?
Lordship, may fix.
Non-payment of MACPS.
MSc Lordship.
Yes. We'll give him some time.
Lordship, Lordship.
Yes, at the request of Mr. P. N. Sharma, matter stands adjourned for 3 weeks.
Date may be fixed, Lordship.
Mr. Your name, please?
Arya Ahmed.
Arya Ahmed appears for the writ petition.
Date may be fixed.
Date may be fixed. Matter be listed on 5th of February.
Yes, Lordship. Item number 52 also similar, Lordship.
Item 52, similar orders. Yes.
Public.
Please, Your Lordship.
Yes.
So this is a file, I shall have a file to reply, Your Lordship. So,
Mr. R.M. Chaudhary, learned counsel for the petitioner, submits that you'd like to file rejoinder affidavit to the affidavit filed by the respondent number 6. He prays for
2 weeks time.
3 weeks further time. 3 weeks time. MS R.B. Bora appears for the BTC.
BTC Lordship, respond,
Mr. Anyone else?
Education Department.
I'm for.
Mr. P. N. Sharma for respondents 1 and
One and two, Lordship.
1 and 2.
I pay for 8.
Mr. B. Gogoi for respondent number 8. And R.B. Bora for respondents 3, 4, 5, 6, 7, and 9.
The respondent not filed their affidavit, only 5 and 6 filed.
Other respondents
They have not filed.
are also
affidavit in
permitted to complete their instructions and file necessary affidavit if so advised. List after 3 weeks.
Deposit.
Wait, please, Your Lordship.
Yes.
Well, although the petitioner is entitled to ex gratia amount money, and it has been said to be released by the authority, but it was not paid to the petitioner. And they are taking time in the guise of malware instruction. And page 69, Your Lordship may feel. In fact, page 67. Page
69.
Last paragraph. 67.
67.
Yes.
Yes.
Last paragraph, we have perused the bills, purchase register and IBCN register from so and so for any amount being received, released as ex gratia amount to the petitioner and to legal heirs of late so and so. We are not able to lay hands over any entry reflecting as ex gratia amount paid to the petitioner and her legal heir. Although it has been said to be released, it was not paid to me. This is the simple case, and they are taking time.
Yes.
Lordship, the bank has allowed the ex gratia payment, but 2 weeks time may be given for initiate the payment.
We are recording your submission.
Yes.
What is the amount?
Amount is 5 lakh.
5 lakh.
5 lakhs.
Yes.
Are you sure? MS so-and-so learned counsel appearing for the UCO Bank submits that the ex gratia amount of rupees 5 lakhs have been decided by the bank authorities to be released in respect of the petitioner. Stop. However, she submits that 3 weeks time be granted to complete the process for initiation of the payment, initiation and release of the payment. Mr. P. J. Soikia, learned counsel for the petitioner, does not object to the prayer made list after 3 weeks on 9th of February.
Much obliged.
Okay. I'm being going to do. Yes, have you gone through?
I have furnished the rules, Your Lordship, the pension rules. If Your Lordship may kindly take up the pension rules, Your Lordship.
Pension rules.
Rule 22 plus B, Your Lordship. If he is in the service of the bank on or after 1/11/1993, after having completed 10 years pensionable service, provided that he has attained the age of 58 years, Your Lordship. But at the time of cessation of service, Your Lordship, in the year 2002, he was aged 36 years, Your Lordship. So he has not attained the age of 58 years, Your Lordship. So he will not be eligible under clause B, Your Lordship.
Your Lordship, on what basis they are saying that? Your Lordship, the age, how they have determined the age, that he was 36 years.
The age can be determined, Your Lordship, in our affidavit in the writ petition itself, Your Lordship. Annexure B is the PF slip, Your Lordship, where the date of birth has been mentioned as 31/3/1966, Your Lordship.
Annexure?
Annexure B, page 11 of the writ petition, Your Lordship. It is the PF slip on the left-hand side, Your Lordship.
Page 11.
Page 11 of the writ petition, Your Lordship.
Yes.
Annexure B, on the left-hand side, below the PF number, it is 31/3/1966. It is the date of birth of the petitioner's husband, Your Lordship, the employer.
From where did you get this date?
Lordship,
From where was this date?
it is mentioned in the PF slip, Your Lordship.
No, PF slip is okay, but from the PF slip, this date must be put in somewhere.
And in the service record also, Your Lordship, it is there 1966, but the same could not be produced, Your Lordship, before this honorable court. So if some time may be given, then I can produce the service record, Your Lordship, in the
Please
meantime.
produce the service.
Lordship.
Your Lordship, the thing is, on last many
You are
occasions,
disputing this date of birth.
Your Lordship, because I don't have any documents. So I'm not in a position to say about it. But the thing is, they have been taking time again and again to produce the reports. That is the thing, Your Lordship.
Immediately after
No, either you say that this 31/3/1966 is the date of birth, or you do not accept the date of birth. It is for you to decide. This is the document enclosed to the writ petition.
Yes, Your Lordship. But whether it is the date of birth or not,
Then
that thing we are not in a position to
don't
say.
you have any documents pertaining to your husband?
No documents.
What happened?
Your Lordship.
What happened to these documents?
Your Lordship, I have mentioned in the writ petition, they all were burnt, Your Lordship.
They all were burned.
Yes, Your Lordship. There was a fire in their house.
And the ground of absence from 2002, Your Lordship, till 2016 is shown as medical, Your Lordship, but not a single medical document has been annexed.
Even after that, Your Lordship, that if he is not entitled to superannuation benefit, then at least he is entitled to voluntary pension, Your Lordship. But that benefit is not even given.
Under which provision?
Your Lordship, according to their own rules, Your Lordship.
The rule? What is that rule?
It's a banking companies. Bank employees pensions regulations, entitlement completion of 15 years of minimum service, Your Lordship.
You bring it on record.
Your Lordship, I would like to place this judgment, Your Lordship.
So you are hampering on the judgment. We do not have the facts which are clear. We are not saying that we'll not go into your judgment. But you at least tell us the facts with clarity. Your date of birth is not known.
Your Lordship, the thing is that.
Where is that rule that you just referred to? What is that rule? What is that rule that you just referred to?
Yes, Your Lordship, it is the bank employees pensions regulations.
Do you have a copy here
Your
in the
Lordship.
pleadings?
Your Lordship, I have only the judgments where it has been mentioned regarding the amendment of their SBA rules, Your Lordship. Because these
Is there
rules
any
are
separate
easy
pension
to-
rules?
I have to obtain instruction, Your Lordship.
What is this?
Because
What,
we-
why don't you obtain your
No,
complete
Lordship,
instructions?
because the SBI employees, they are, as per my instruction, they are only governed by this rule, which I have produced before Your Lordship.
Then why do you say it is, you have to be obtained?
It's because he is submitting that some development has been carried out.
What is the judgment? Let us see quickly. When a standing counsel appears, you are expected to be posted with complete instructions. This habit of playing hide and seek is not advisable. Yes, which paragraph?
Your Lordship, I have marked there.
Do you not have a copy with you?
Yes, Your Lordship.
Refer to that paragraph in the judgment.
Yes, Your Lordship. This page number 2, Your Lordship.
Hmm.
Point number 4, a voluntary retirement scheme was floated by the bank on 9/11/2000. Respondent requested to his voluntary retirement. It was accepted by an order dated 10/2/2001. By then, he had completed 14 years, 9 months, and 17 days of service. He filed an application for grant of pension on the premise that he was eligible. Therefore, it was rejected on the ground that he has not completed 15 years of service. A writ petition filed by him was dismissed by learned single judge of Madras High Court. An inter-court appeal filed thereafter against has been allowed by division bench of the High Court by reason of the impugned judgment directing. Accordingly, while setting aside the order impugned in the writ petition, we direct the respondent to grant pension.
You are relying on this voluntary retirement scheme.
Yes, Your Lordship, not, it is rule, Your Lordship, amended rule.
You are
I
referring
have
to
given another judgment of.
para 12, para 12.
Pensions regulations here. A circular letter was issued by the appellant, which is in the following terms: voluntary retirement scheme in public sector bank, amendments to bank employees pensions regulations 1995.
You are referring to this regulation.
Yes, Your Lordship. That is for the whole bank employees.
Now, where is that regulation? You find out and refer to the, rely on this.
And another, yes, Your Lordship. That is, your, point number 13, Your Lordship, page number 4. It may be true that various provisions of the regulations, as for example, regulation 16, 17, 19, 23, etc., provided for qualifying service. Regulation 18 is not controlled by any of the said provisions. It does not group any restrictive interpretation. It only provides for a rule of measurement.
So therefore,
And
we'll have to
employee-
look into this regulation. Where is that regulation? That is what we are asking you.
Yes, this regulation is not easily available, Your Lordship.
It will be available in public forum somewhere. You are a counsel, you must know where to find it.
Yes, Your Lordship. And in the another judgment also.
You
that-
make your efforts to find out. Don't expect everything to be done by the court.
Yes, Your Lordship.
Yes, Mr. Standing Counsel,
Lordship.
please produce the relevant rules, regulations.
Lordship, as per my instruction, only the SBI employees are governed by these rules which I produced before Your Lordship.
What about this voluntary retirement scheme?
These are schemes, Your Lordship. There are several banks. They have come together and they have formulated that rules which are not applicable to the State Bank of India, Your Lordship.
You show us the material on which it is not applicable.
Lordship.
Your Lordship, in the another judgment which I have given, that is also applicable in case of SBI employees, Your Lordship. I have marked the relevant provisions, Your Lordship, regarding the amendment of their regulations.
There is an SBI voluntary retirement scheme, 2002.
It is there, Your Lordship. And for that, the petitioner or the person who is claiming it has to go and apply before the bank, Your Lordship.
Will your bank officers mind if we go through the regulation? Will they have any difficulty if the regulation is placed before the court, for the court to peruse?
No, Lordship.
Then why is it not being produced?
So this has come up today only, Your Lordship. That's
You
why-
just mentioned that all the other banks have got together for a voluntary scheme and that is not applicable to SBI. You
Lordship,
should have pointed out that there is a separate voluntary retirement scheme.
Your Lordship, if there is a scheme of the bank,
So
Your Lordship,
who's instructing you?
Your Lordship, the regional office, Your Lordship.
You call the regional manager.
Lordship.
You call the regional manager. We'll have to find out what is this going on. Why are you not placing the instructions? Why are you withholding instructions from the court?
I'll inquire, Your Lordship.
Your Lordship, if I'm allowed, I would like to carry your attention to point number 13 of the another judgment which I have given to you, Your Lordship.
Let us first procure the schemes and the regulations, then you can continue with your argument.
That is Regulation 28 is mentioned there.
In terms of the earlier orders, the learned standing council was required to place the relevant rules or regulations governing the pension and other service conditions. Mr. H. Boraguhai, Learned Standing Council, SBI, has produced an extract of the, what are these?
Your Lordship, the first one, Your Lordship, in color print, Your Lordship.
Yes.
It is the pensionary benefits probation confirmation extension. It is the
These are part of what?
extract of the handbook, Your Lordship. Extract of the handbook of service rules, Your Lordship.
This are an extract of the handbook of the service rules / regulations governing the services of the officers and staff of the SBI. Stop. During the course of the hearing, the learned counsel for the petitioner, relying upon judgments of the apex court, rendered in so and so versus so and so. AIR Online 2020 SC 273 submits that from the judgment, it is evident that the SBI also has its own voluntary retirement scheme 2002. However, this scheme is not available in public forum and therefore she is unable to procure a copy thereof. Stop. Mr. Boraguhai, Learned Standing Council, submits that he does not dispute the submission and prays for further time to place the complete rules and regulations, including the voluntary retirement scheme 2002 before this court. Stop. Vera. This court deprecates the conduct of the respondents in withholding appropriate instructions from the court. The directions of the court are with regard to production of the relevant rules and memorandums. Stop. However, today, during the course of the hearing, only an extract of the so-and-so regulations have been produced. That apart, the voluntary retirement scheme 2002, which Mr. Boraguhai subsequently admitted is followed by the SBI, which governs the voluntary retirement schemes under the SBI, is also not placed before the court. Under such circumstances, only for the ends of justice, we permit further time of 2 weeks to the Learned Standing Council to procure all relevant records. The respondents are put to notice that in the event the relevant rules and regulations which are sought for are not available, consequential orders may be passed against the erring officials. List on 6th of February. On the next day, you re-agitate the judgments. Yes.
Also, can I say that it will be fixed on 10th of February? Your Lordship. 6th, I'm having some difficulty.
10th of February is a Sunday. You can have it on 13th February.
Lordship.
Yes, yes, what is the issue here?
Well, here these persons, they were denied their salaries on the ground that they were not appointed on regular sanction post after having gone through a regular selection process. They had approached the honorable,
You're putting to
Act.
challenge the order of
Order
the
of the Act.
administrative tribunal.
My lord, the two situations arise, my lord. 7 and 8 are those writ petitions where the petitioners were granted relief, while the rest of the writ petitions are those where the tribunal had denied to grant the relief. The petitions were dismissed. Now, the same class of persons, two orders were given granting them the relief and another 5 not granting the relief. Now, when we filed our writ petition, they also filed a writ petition claiming the relief given to them, given to the others. Now, as of today, my lord, I have just had a discussion with my friend here. We find that several of the respondents in the state's writ petition and some of the petitions in the other writ petitions have been accommodated as tutors in the government now. And they have accepted those appointments with a precondition that they would give up all the past claims. Probably, my lord, my friend has to take some instructions from his clients.
No, these statements are supported by any official documents here.
My lord, which one that they have
accepted the appointments with
my
the
lord, those
condition?
appointment letters, 2015 matter, I just had the records, I went to the list. These persons' names are there in the persons accommodated.
You
and
produce
accepted.
that list.
I'll have to, my lord, I'll bring the acceptance notice I have to bring, my lord.
You
That they've
produce the
accepted
list
the
along,
appointment.
along with the letter or whatever is there.
My lord.
But if they're entitled to the claims
My
merely because they have given a consent, can it be waived?
My lord, with the knowledge that they had a order in their favor and they go ahead to accept it, unless they challenge that particular clause, my lord.
They have no option but to agree with the government.
That is what they will come and say, but if they accept it and keep quiet about it, my lord, I cannot have it.
Counsels for the parties, Mr. R. Muzumdar for
The
writ
writ
petitions
petitioners in 7 and 8.
WPC, in WPC so and so, where state is the party, state is the petitioner. And Mr. S. Sahu, appearing for all the other writ petitioners. All the other writ petitioners were private. Filed the writ petition. It is submitted by Mr. Muzumdar that some of the respondents in the writ petitions have in the meantime accepted the appointments which are offered. Some of the litigating parties have in the meantime accepted the offers of appointment given by the state. And they have also given their consent to not to press the earlier claims. Mr. Mazumdar, however, is not posted with the relevant documents. He prays for a short date to place it on record. Place it before the court. List on. When can you produce it?
Sometime between 5th and 9th February, my lord.
8th February.
I'm obliged, man.
Yes, Lordship, I have received the instruction, Lordship. Here, petitioner number 1, petitioner number 3, petitioner number 6, petitioner number 5, and petitioner number 4. Their pension has been finalized by the pension department, Lordship. But petition number 2 and 7, their pension has yet to be finalized by the director of pension, but they are getting the provisional pension. This is the instruction from the district that I have received. I kindly did understand.
Their pension has been finalized, but they have not been given the benefit of final pension.
That petition number 2 and 7.
No, the others?
Others, they are finalized by
No, finalized, but
Yes.
not released.
PPO, that PPO number is given, Lordship.
Okay. Have you gone through this?
No.
Let him go
Yes,
through it.
I'll give.
Mr. SMT Chisti Leonard, Standing Counsel Secondary. submits that except for respondents 2 and 7,
Yes.
except for petitioners 2 and 7, the other petitioners' claims for pension has been finalized and respective
Director of-
PPOs have been allotted,
Yes.
have been issued
By the director of pension.
by the Director of Pension. Stop. Insofar as petitioners 2 and 7 are concerned, their cases are under active consideration and likely to be settled within a very short
And they are getting provisional pension, Lordship.
And the petitioners 2 and 7, however, are in the meantime being granted provisional pension.
Yes.
Where Mr. R. Ali, Learned Counsel for the petitioner, submits that he would like to complete his instructions with regard to the submissions made by the Learned Standing Council regarding finalization of pension in respect of all the petitioners except petitioners 2 and 7. Let the matter be listed again after 2 weeks.
Yeah. I have given a copy in the mail that can be kept in the record of it.
Right. Take out a copy and put it in the file. Copy of the instructions furnished by the respondent counsel is kept in the case record.
Obliged, sir. Obliged.
May I please, Lordship?
Yes.
Lordship, grievance of the petitioner has been redressed, my Lordship.
Redressed. Mr. M. Mohanto, Learned Counsel for the petitioner, submits that the grievances of the petitioner has been redressed and therefore he does not wish to press the writ petition any further. Ms. M. Bhattacharya, Learned Counsel, appears for the respondents. Accordingly, writ petition stands dismissed as not pressed. Interim orders, if any, shall stand vacated. Pending IAs are also dismissed. Yes.
Obliged, your lord.
Lordship, in this case, I am appearing for respondent number 3, Lordship, that is private respondent. Petitioner challenge the transfer order, Lordship.
Now what happened?
There is a stay order is there, Lordship, and Honorable Court give direction to produce record to Karbi Anglong Autonomous Council.
None appears for the petitioner on call. You are appearing for?
Respondent number 3, Lordship.
Who is respondent 3? MS
R. Deka.
R. Deka appears for respondent number 3. For the private respondent.
Lordship.
List again next week. After 1 week.
Obliged.
May I please, your lordship? Respondent supposed to file affidavit, my lord.
Respondent's affidavit.
Elementary division, my lord.
Yes.
Lordship, here we have to file our affidavit, Lordship, page number 33, that order that has been improved. In pursuance of the government notification number so and so dated so and so, the contractual estate pool of other staff of SSA have been drawing 17% DNS allowance. Meanwhile, the government of finance department further enhanced so and so. So in terms of the finance approval, Lordship, approval of the finance department, this DA has been released, Lordship. So we are going to file our affidavit. Perhaps the finance also need to.
I heard MS P. Bora, Learned Counsel for petition. Respondents are represented by Mr. P. N. Sharma for
I am for respond number 1, 2.
elementary.
Lordship, 1, 2,
elementary
and 3,
education.
Lordship.
And Mr. S. Bora for SSA. And Mr. Borpujari for finance. Let the respondents complete their instructions and file their counter affidavit if so advised. List after 3 weeks.
Extra copy, Lordship.
Yeah.
Yeah. Finance.
Lordship, is a case of non-payment of salary upon provincial. Lordship, may kindly see page 21.
Rule has been issued.
My lord,
Rule has been issued in the matter.
rule has been issued.
Why is it listed for admission?
It is wrongly listed.
So let it come for hearing.
It can, if it is going for hearing, my lord, it will take more
Are
time.
we taking up hearing matters now? Huh? This is admission.
My lord.
Let it come for hearing.
My lord,
By order dated 2012-2022, rule has been issued by this court. The matter was wrongly listed for admission. Registry to list this matter for hearing.
in the month of March, my lord,
In usual course.
usual course, my lord, is a non-payment of salary.
In the month of March, yes.
Okay, may I have a date, my lord?
Sorry, date.
Ma'am.
It will go in the,
At the end of the March or so, it will.
no, it will come in the hearing list. In the part 2 hearing list. You are entitled to make a mention and upgrade it. We'll take it up.
May it please your lordship. Lordship, this petition is filed from recovery of the retirement benefits. The opposition have filed their objection and we have also filed a reply accordingly.
Okay. Is there any interim order?
No lordship, no interim order.
May I please, your- I'm sorry, my lord. I'm
It's all right, it's all right. You have filed your counter.
Yes, my lord, file. Well, it is different. He has taken a special patient care allowance, my lord, and special. He is not entitled for that benefit because he is a accountant.
All right, we'll hear the matter. It is submitted that the pleadings are completed. Matter be listed
file
for admission hearing in the month of March.
Date may be fixed, lordship.
Registry will fix a date. Yes.
Like lordship.
May I please, your lordship, my lord, leave salary and the arrear revised pay of the petitioner has not been paid, my lord. Kindly see, my lord, here is the order date 19/5/23.
PNRD. Yes.
Mother, I have received paragraph comments, but specific instruction in this regard has not been received.
There is a specific direction, what steps you have taken pursuant to 7/12/2022.
Yes, sir. As far as that, this specific instruction, I have not received, madam. Paragraph comments.
Mr. R.S. Chauhan appears for the petitioner. Mr. Devnath appears for PNRD, who submits that instructions with regard to the steps taken by the department pursuant to the order dated 7/12/2022 passed in WPC 7854 of 2022. And as to whether any reasoned order to that effect has been passed by the commissioner has not yet been received. The praised accommodation for a further 2 weeks' time. Counsel for petitioner does not object. Mr. S.K. Medi appears for the respondents.
3.
Respondent 3. Who is respondent 3?
Accountant General.
Accountant General. Let this matter be listed again on 6th of February, by which time the respondents are permitted to complete their instructions.
That pleases your lordship. We will be filing our affidavit today itself, your lordship, in due course today.
This is the matter, selection to the post of principal diet. This has to be finally heard and decided, my lord, at the admission stage itself. If your lordships, can you take up the matter immediately after the Bihu vacation on a fixed date?
They are stated to be filing something.
Today itself, they
Today
have.
we will be filing
Ah.
our affidavit, your lordship.
So in the meantime, if some reply is required, then I can file my.
Very good. Yes.
Appear for the private respondents, your lordship, 6 to 14 not. So there's some urgency on our
Nine.
part.
I have also, my lord, serious urgency, my lord. 19th is a Friday.
MSP Das, Learned Standing Counsel, Learned Counsel appearing for
SCERT, your lordship,
SCERT.
on behalf of
Submits-
P. Nair.
Submits that affidavit will be filed within this week. Mr. H. Das, Learned Counsel for the petitioner, as well as Mr. Gautam, Learned Counsel responding the private respondents, jointly submit that matter requires urgent hearing. Therefore, matter be listed on
19th, your lordship.
Hmm?
19th, your lordship.
19th is a Friday, my lord.
19th of
Hearing day will be better, my lord.
20th of February.
28.
A bit early date if possible, my lord. In the February,
28 January, Saturday
28th of February, kuch hai.
of February.
In the February itself, a bit early.
15th February.
15th, fine, my lord.
15 February.
Interim order, my lord, that may continue.
Interim order, if any, will continue till the next date of listing.
My lord.
You are appearing for?
6 to 14 not.
Yes.
Highly applied.
Deeply obliged.
Now that this matter of private domain has been received, some time may be granted to file the affidavit.
Yes, Mr. Counsel, he wants to file his affidavit.
The respondents were supposed to submit a affidavit, they didn't submit. So
He says he has received his comments, he wants to file it. We'll give him a short date.
Short date. Okay.
Mr. N.K. Devnath, Learned Standing Counsel, appearing for PNRT, submits his instructions or something. He is required to file an affidavit on behalf of the department. He prays for 3 weeks' time. Mr. J.P. Soikia, Learned Counsel for the petitioner, submits that the matter be listed. At an early date. Accordingly, prayer made by the respondents are allowed. Matter be listed again on 9th of February.
Obliged.
My lord, 63 and 64 are similar, my lord. That's challenging the
Lordship,
accommodation.
here the petitioners, in terms of the cabinet memorandum of 2020, lordship have been accommodated as tutor and they have accepted and they have joined lordship. We are going to file our affidavit here. They have been accommodated as tutor.
What have they challenged here?
They are asking for the regular pay.
When initially we were appointed against scale of pay, my lord. As per cabinet memorandum, our service has been accommodated on fixed pay, my lord, under a wrong act, my lord.
Lordship, their initial appointments were illegal and in term, they were made to
And
appear
we are
before the
also
screening
claim-
committee.
We are also claiming for minimum wage, my lord, because we have been paid only 10,000. And one petitioner after 30 years of service, he will be retaining this year.
You are,
So that may be given.
you are retiring.
Not matter, we will be retiring, madam.
Ah.
9 years of.
It is submitted by Mr. P. N. Sharma, Learned Counsel, Standing Counsel for the Education Department, that you have completed your instructions.
Lordship, I have received the instruction that
Submitted
they have
his
been, both
instructions
the
are
petitioners have been accommodated as
Would
tutor.
like to file the affidavit. Mr. A. Deka
And Sharma.
does not object, appearing for the petitioner, does not object to the prayer made list again after 3 weeks.
Lordship, obliged.
Date may be fixed, my lord.
We are going to
Any date, my lord.
16 February.
Lordship.
63, 64, huh?
63 and 64.
Yes.
May it please, my lord.
May kindly see the last order, my lord. The departmental proceedings against the petitioners were stayed, and the issue with regard to grant of provisional pension was to be decided today, my lord.
Yes,
Well, I have received the parawise command instructions. My lord,
let the affidavit come on record.
let me-
Provisional pension at least, my lord, can.
No, my lord, here the issue is something like this, my lord, where Lordship will kindly see, my lord, this is also my instruction. Lordship may kindly come to, my lord, page 65 of the writ petition, page 65. Prior to that, Lordship will find the inquiry report that begins from page 39. Inquiry report has been, my lord, submitted, and the inquiry report was also furnished. And my lord, a second so cause notice, my lord, as a matter of abundant precaution, my lord, was given to the petitioner. The petitioner, my lord, he has not replied to this. Therefore, my lord, the department had to go for even paper publication at page 65. My lord, that is awaited, and my instruction says, my lord, my lord, that reply, his response, my lord, to the inquiry of, my lord, report, my lord, that is still awaited. This is the, my lord, department's instruction. So for that reason, my lord, since the inquiry has been stayed, my lord, the departmental proceeding could not, my lord, be culminated into a conclusion, my lord. That is the difficulty. My lord, let me file an affidavit, my lord, because he has already superannuated. And there is also, my lord, a criminal proceeding pending against him. Of
But
course,
that-
my lord, of course,
We've
my
been
lord.
exonerated, my lord. That is a wrong submission, my lord. He's been honorably acquitted, my lord, and these departmental proceedings were initiated in
No, you
2000.
file your reply.
Yes,
My lord, the provisional pension, my lord, that he has a right to at least the grant of provisional pension, my lord. He retired in the year 2019.
2019, he retired, my lord, that is, my lord.
Heard learned counsel for
He has
parties,
filed a
the
petition in
learned
2023, my lord.
standing counsel, Mr. For the finance, Mr. R. Borpuzari submits that the instructions are complete. You'd like to file an affidavit.
Yes, my lord.
Mr. Chaudhary,
My lord.
learned counsel for the petitioner submits that petitioner is a government servant, superannuated,
Super.
is a government servant who superannuated from service and therefore is entitled to provisional pension. And as per the last order, the matter was fixed today for consideration of the prayer for provisional pension. Stop. Since the learned standing counsel submits that the instructions are complete and the affidavit will be filed on a short date,
Yes, my lord.
this court considers it appropriate to this court will consider the prayer for provisional pension after the affidavit has been filed by the respondents. However, this order shall not operate as a bar for the
Yes, yes.
petitioners
Yes,
or the
yes.
respondents
Yes, in fact, I have already duly communicated.
consider
last.
the claim of the petitioners to release the provisional pension in
Yes,
the meantime.
Yes, my lord.
Mr. S.K. Medi appears for accountant,
Yes, Respondent.
accountant general.
Yes, my lord.
Mr. C.K.S. Borua for respondent 6. Let the matter be listed again on 20 February.
How the interim may be continued.
Interim order will continue until further orders.
My lord. I will file my affidavit, my lord. I'm so obliged.
May it please the Lord. Well, this case is also relating my lord non-payment of pension or benefit to be paid. Although he has been paid my lord everything except the pension my lord.
Lord,
What
I
do
am
you say?
praying 3 weeks time for obtaining of it.
3 weeks time.
Yes,
Next
Lord.
time pension
Instruction.
matter my lord. In that event my lord, may I pray for a direction my lord to pay my lord provisional pension to be paid.
They have already sent a letter.
Mr. Ronghang, learned standing counsel, Karbi Anglong.
Yes, Lord.
Submits he is not received instructions, he prays for further time. Mr. P.J. Soikia, learned counsel for the petitioner, submits the petitioner has retired from service. However, the pension has not been released, therefore he is entitled to at least provisional pension. Let the matter be listed after 3 weeks enabling the respondents to complete their instructions and file necessary affidavit. Stop the respondents will also consider the claim of the petitioner for release of provisional pension in the meantime. List after 3 weeks. Arbiter order. Yes.
I prefer some time loss. First, now 3 weeks time loss. The instruction is awaited.
Mr. T.N. Sharma, Standing Counsel, prays for further time to complete his instructions and file affidavit if so advised. Mr. Islam does not object to the prayer made. He, however, submits that the interim order passed earlier be extended in the meantime. Accordingly, let the matter be listed again
After 3 weeks loss.
after 3 weeks on 19 February.
Loss.
Till the next date fixed, the interim order passed earlier will continue.
Must
list accordingly.
Okay.
That is lordship. While of that payment of honorarium of rupees 900 to the female attendant, it is under process, my lord, their particulars have been sought for. It will require some time, my lord. There, some persons have been found, they've already expired. Their legal hairs have come up. It is under process, lordship will take it up after, my lord, 4 weeks, my lord, in the meantime.
4 weeks.
My lord, or 3 weeks, my lord. No, they are aware, my lord.
17
Last few months, my lord, it is under process now, my lord. For a long
What is
time.
there to be processed for so long? If they're entitled, then it should be allowed.
Direction was there, lordship.
There is a specific direction.
Let it be after 3 weeks, my lord, at least. I will take the step. Let us.
Many times this honorable court might have directed lordship during this proceeding contempt of the law. Budget, my lord, in the meantime, budget was also there, lordship. That was left, lordship. This is also, this time also, lordship, budget is
No,
created.
no, no, that's why, my lord, let it be 3 weeks. my lord.
2017,
I understand.
7 years.
I understand.
You are still processing.
My lord, after March, my lord, there is possibility lapse of budget.
Then you pay some cost to compensate.
That lordship
7
will-
years.
No, that lordship will impose such cost if necessary, my lord. Let it be after 3 weeks, let me have the instruction.
We already are convinced it is necessary. 7 years you are processing.
Lordship may indicate in the order that lordship will impose cost if something concrete doesn't come out of that period. I will at least convey. Something may be there in the order.
Mr. Gogoi Learned Standing Counsel, Health. You give us a specific date,
Yes, lordship
specific
indicated
period
in the order.
that this, at least partially, it has, some of the petitioners ought to have been released. What is this?
In fact, my lord, now they are, my lord, taking up that so far as the contempt petitioners are concerned, they will be paid. Not all, my lord, now they are verifying 3,000 odd, my lord, person. Instead of
We are
that, my lord,
fixing it on 6th.
6, yeah.
You get your instructions.
Lordship may indicate in the order, at least I can communicate.
The the Council for Respondents submits that matter is under process, but payments regarding arrear honorarium to female attendants has not been released as on date. Learned Counsel for the petitioner submits that this order, this direction to release the arrear honorarium was passed in the year 2017. So considering the delay which has occurred, this court is of the view that this matter needs expeditious disposal. Accordingly, the matter is directed to be listed again on 6th of February. The respondents are expected to comply with this order.
But
as
the official respondents are not there, my lord. Long back, they have, my lord, been transferred, my lord, some retired.
whoever is there in their place,
Yes, yes. I will convey.
that this, the respondents are directed to comply with this order. More particularly, the directions that para 19 of the judgment and order dated so and so, telling which this court will consider initiating proceedings under the Contempt of Courts Act 1971 and pass consequential orders. Copy of this order be marked to the office of the Standing Council. What is it? Health.
Health and finance. both.
Health and finance. Not health and finance. You are appearing in
Yes,
contempt matter
yes, to the matter.
to the respondent
Council,
council.
yes.
Matter be listed on 6th, by which date the respondents are permitted to complete their instructions with regard to compliance of the directions contained in the court's order dated so. Mr. Das, you are appearing for?
Action respond about in item 77.
So
Mr.
can it
Das
be, my lord,
appears for respondent 2 in
on
item
13, my lord, at least one more week may be given. At least something, let them come up on 13.
13. You are sure 13 is lucky for you?
Then, my lord, 16. my lord.
Then it's 16 or 13, no problem, Lord.
Let it be 13.
It should be complied with, Lord.
No, 14, my lord.
14 is
No, no, 13. 13 is
Alright,
a good date.
My, hold it.
Yes, yes, yes. Why is it come for orders?
My lord, actually the.
Rejoinder affidavit.
Matter
You are supposed to file rejoinder affidavit.
My lord, no need, my lord, but actually, my lord, because.
Infractuous.
No, my lord.
Then?
It has to come up for admission, it has to be disposed of, my lord.
Ah. Okay. Mr. M. Soronia, learned counsel for the petitioner submits that no rejoinder affidavit is required.
No, my lord, I will not file, my lord.
In that view of the matter will be listed for admission. Mr. Decca appears for the
Respondents, my lord.
all the respondents.
All the,
All the respondents.
Only three of the, my lord, respondent authority.
not
I
all the respondents.
taken up today also matter, my lord,
Today,
because it is some pensionary benefit to the petitioner due to death of his son in the Guwahati refinery, madam. Only thing is that, my lord, the respondent authorities, my lord, they have agreed that I am entitled. Only thing is that, my lord, they need succession certificate. In case of pensionary benefit, my lord, until and this amount is ascertained, it is difficult to get a succession certificate. And a pension, in case of pension, I think succession certificate is not at all required.
then we'll hear the matter. Let the matter be listed on 8th of February, subject to your availability.
My lord, my lord,
8th of February.
my lord, I'll be available. I'll be available.
8th of February for admission.
May it please your lordship.
Ah.
Lordship, in this matter, notice was issued, lordship, and as per office note dated, lordship,
Why is it come before this court?
lordship, perhaps lordship has issued this notice and this matter has been listed before your lordship only.
Okay. Now,
Notice, lordship, in respect to item number 80, lordship, that is Diganta Kumar Das, lordship, this answer notice has been received, lordship. The addressee left. Item number 80, lordship.
who is respondent to?
Number 2. Oh. Shafiqul Jamaat. And
then?
the rest, lordship, service report awaited, lordship.
Huh? On respondent 2.
Yes, lordship, on respond number 2.
But it has been returned unserved.
Unserved, the addressee left.
Huh?
With respect to item number 80,
Yes.
addressee left, and rest service report is
No,
available.
with regard to item 80, what is to be done?
Oh, lordship, we have to take a fresh step, lordship. We have to take a fresh step, lordship.
You have to take a fresh step, but do you have the address?
Oh, lordship.
Then? Office note dated 8/1/2024 reflects that service on respondent number 2 has not been complete and the notice was returned unserved with the endorsement within quotes addressee left. RTS. Quotes closed. Stop. The learned counsel for the petitioner is permitted to take fresh steps on respondent 2 after ascertaining the correct address. MS
And thus, Lordship.
L. Das, learned APP APS for the respondents. And in other matters,
Lordship, service report awaited, Lordship.
now file. In the other matters, service on respondent number 2 is awaited. Matter be listed after 4 weeks.
Interim order is
On 1st of March. Interim order passed early will continue till the next date of listing.
applied. Already, Lordship.
Yes. No affidavit is filed, not required.
Hello?
No affidavit is filed with the respondents.
So in one of the cases, it has been filed.
Okay. Are you addressing that matter or?
No, I am addressing some other matter.
Okay.
But the issue is, my lord, in fact, the FPD is not required because the question is on Article 14 of the Constitution.
You are taking up this
Taking
2068,
up item number 23.
item 23 today. One double two three. That one. No, it would. 2068, yes. Yes, please.
Well, the government of Assam, time to time, announced various industrial policies, granting various incentives to the new industry units, as well as the industry undertaking substantial expansion, etc., in the state of Assam. One of such industrial policy was announced on 1/10/2008, which is the industrial policy made effective from 1/10/2008 and was to remain valid for 5 years up to 39/2013. Now, my lord, by this, my lord, which you also find it annexure 1, various incentives were announced, including, my lord, the incentives for VAT remission. And in that VAT remission, it was made subject to, my lord, a total of the percentage of the capital investment, and period was for 7 years. Now, to give effect to that, my lord, a remission scheme was framed, which is known as, my lord, Assam Industries Tax Remission Scheme, Tax Exemption Scheme 2009, and exercise of powers under Section 54(1) of the Assam Value Tax Act and Section 8(5) of the Central Sales Tax Act. Now, that scheme was framed, which is there in Annexure 2, my lord. I'm not taking philosophy to those policies and schemes because there is no dispute about all those things.
Yes.
Now, my lord, being inspired by the provisions made in the 2008 industrial policy and the remission scheme, the petitioner established a new industry unit
in the state of Assam. And on the ground, below, the petitioner will be entitled to avail the benefit of the VAT and CST exemption emission for a period of 7 years from the date of the commencement of the production. Now, the petitioner, in order to avail the VAT emission under this policy and the emission scheme, applied for the issuance of the eligibility certificate before the appropriate authority, and the same was granted, which will also find at Annexure 3. Now, this was valid for a period of 21/9/2013 to 29/2020, subject to the maximum of 100% of the eligible capital investment of the unit, which was 11 crores 83 lakhs 84,569. So the exemption was limited to 11 crores something, and the exemption was valid for a period of 7 years.
Yes.
Now, my lord, after the issuance of the eligibility certificate, an entitlement certificate is also required from the tax department. The petitioner applied for it, and the same was also granted to the petitioners on 27/2016, which you'll also find at page Annexure 4.
Yes.
From 1/7/2017, my lord, the goods and service tax regime came into it, and the Assam Value Tax Act was repealed, and instead of Assam Goods and Service Tax Act was enacted. And all the central laws, like the Central Sales Tax Act, etc., and the other laws were repealed, and instead of that, Central Goods and Service Tax Act and Integrated Goods and Service Tax Act was enacted. Now, on 10/1/2018, because you also will find that the promise was made in the industrial policy of 2008 for granting the VAT remission for a period of 7 years, and in between, the goods and service tax regime came. So, in order to stimulate industrial activity, attract investment in the state, etc., a scheme was framed, which you'll also find Annexure 6. Annexure 6, my lord, at page 165.
The earlier scheme was repealed.
My lord, the earlier scheme was repealed.
Repealed. 2009 was repealed.
My lord. Now, you'll also see at page 165.
Yes.
He said, my lord, in pursuance to the industrial and investment policies of Assam, announced by the state government from time to time, with object of attracting investment for promote industrial and generation of the employment, various exemptions were offered to eligible manufacturing units and specified service sectors, and such tax incentives were granted to the respective industrial tax exemption schemes, so notified by the government, published pursuant to such policies by the special notifications in case of the customized incentives under the various policies. Whereas under the erstwhile Assam Industries Tax Concession Scheme 2009, framed pursuant to the Assam Industries and Investment Policy of Assam 2008, an eligible industry unit is entitled to partial tax exemption for 7 years from the date of the commencement of the commercial production, subject to the monetary ceding of to the merchants to certain percentage of the capital investment, and such unit is entitled to retain 99% of the tax amount by way of subsidy or remission, and is required to deposit only 1% of the tax amount to the government on so and so. And whereas the existing Assam Industries Tax Concession Scheme 15, framed thereafter 2015 also was framed. So they are mentioning about 2015. we can skip over, below.
Yes.
And whereas following the enactment of the Constitution first 101st Amendment of 2016, the Assam Goods and Service Tax had been introduced in Assam with the rest of the nation with effect from 1/7/2017, which has brought out a package or a package which shift by replacing the multiple indirect tax levied to the center and of the states with a single tax which ensures so and so. There is no necessity of this one. Thereafter, my lord, whereas as the existing system of, my lord, this is also they are stating about that why GST regime will come to later, my lord. Whereas the state government by notification number so and so dated so and so notified that the Assam Industries Tax Exemption Scheme and the Assam Industry Tax Exemption Scheme 2015 respectively shall cease to operate on and from the date of coming into force of the Assam Goods and Service Tax Act 2017, that is 1st of July 2017, and all eligible units availing tax exemption under the said scheme shall be liable to pay tax under the Assam Goods and Service Tax Act 2017 from the date of coming into force of the said act, and the state government shall notify appropriate scheme through which the existing exemption shall be reimbursed to the eligible unit. So, my lord, in view of the coming into force of the GST Act, my lord, after repealing of the Assam VAT Act, the earlier notifications, schemes of 2009 and 2015 were came to cease to be operational from 1/7/2017, and were notified that the government will, my lord, come through a separate scheme to, my lord, to reimburse the tax to the eligible units. And whereas in order to accumulate industrial authority, attract investment in the state, generate employment opportunities, and so and so, and to provide reimbursement to tax so and so, my lord, the industrial policy of 2008 or under the Assam Industrial Policy of 2014 and covered by the earlier schemes or special notifications to the extent of unavailed monetary incentives and for the residual of the expired residual or unexpired time period for such unit of the limits of the eligible unit be to the eligible unit of the expansion of the expansion unit which commencing their commercial production during the period commencing from July 2017 to 31st December 2022 in terms of the eligibility criteria of industrial and so and so policy 2014. The government of Assam is hereby pleased to notify the Assam Industries Tax Reimbursement to the eligible unit scheme 2017 so and so. So 2017 reimbursement scheme was framed, and it was mirrored for the industry units which were governed by the 2014 and 2000 mirrored this scheme of 2008 for the unexpired period and the unclaimed benefits mirrored, remaining uncompleted benefit. For that, mirrored, the reimbursement will be granted under the said scheme. Now, what happened that under the earlier schemes, the exemption was also under the CST Act also. But under the GST Act, it was only, since it was only under the GST, local sales, and the CST was now subsumed in the Integrated Goods and Service Tax Act. So the exemption of the petitioner was reduced because the payability on the Assam General Goods and Service Tax Act became less, and then whatever was payable earlier. Now the government was aware of this, that the petitioner, the industry unit may not be able to avail the benefits during the period which remain unexpired, the entire exemption period. A provision was incorporated, my lord, that you will also find in para 4 of the said scheme. Yes, sure.
Yes.
Give me 1 minute. Below your lordship, you see at page 169, clause 2, proviso below. Provided that if an existing eligible unit, including a mega unit, to which the customized that is incentives have been granted, is unable to utilize or avail of the full amount of the monetary ceiling within the specified period of exemption, it may make an application to the Finance Taxation Department for extension of the period of eligibility. Upon examination of such application, if the Finance Taxation Department is satisfied that the unit could not or is not in a position to attain the full quantum of the monetary ceiling due to some genuine reasons, and in order to sustain the industrial units, it is necessary to the extent of to extend such time limit, it may by an order extend such time limit by a further period not exceeding 5 years. So, my lord, the proviso was there, my lord, that in case the said amount could not be availed within a particular period, and if an application is made to that effect before the approval of the Finance Taxation Department, the Finance Taxation Department will consider such an application, and if the Finance Taxation Department finds that yes, the benefit could not be availed and it is necessary for the purpose of sustaining the industry unit, the period will be extended for a further period of 5 years, not exceeding 5 years.
What is the meaning of availing the full amount of monetary ceiling?
Well, that was the amount that is like 100% of the fixed capital investment was the amount. That is the total amount which maximum which one can avail. Now, assuming I invested 1 crore rupees, so 100% of that, that is the maximum limit of the availing the benefit. And that was to be availed within a period of 7 years. Now, assuming I could avail after the GST introduction, all those things, 70 lakhs only. Now, 30 lakhs remained, which could not be availed.
That is till the date of GST. GST
Till the after the expiry of 7 years period.
after expiry of 7 years.
Till the expiry of 7 years period, I could not avail.
No, that is after coming in the GST, you, for 7 years, you have to avail it after 7 years or within 7 years?
7 years from very beginning, from date of the commencement of the production. Now, commencement of the production, I started in 2013. 17 the GST came.
That is what we're saying. So 7, you have to avail it within a period of 7 years.
Balance the period whatever is there from 13 to 17.
No. Initially, the scheme is that 7 years you have to avail that 100% or 50% or whatever is to be done. But because of the GST, you could not avail the entire amount or the entire period.
The GST first said that the unavailed period, extended period, will continue. So from 2017, 13 to 20.
7 years. Yes.
Total 20. So after GST, 3 years will be there, more will be there. Now it's said within 3 years, it may not be possible for industry need to avail the balance amount which was remained. But when the GST came, my utilization was only 50 lakhs, assuming from 1 crore. Now 50 lakhs I had to utilize within balance 3 years under the GST law. Now, if I could not avail it, because as I submitted for lordship, earlier CST was also exempted. Now, under the GST Act, the question of CST is not there. So the exemption was reduced because the payment of liability under the GST Act was reduced. So the exemption availing was also reduced. So it said that if any industrial unit could not avail the entire benefit within the total period of 7 years because of the introduction of the GST, then he can apply for extension of that period. Amount will remain the same. Amount will not change.
Apply for extension of the balance period.
Of the period, after 7 years, he can apply for extension of further period.
Okay.
Because the amount will remain the same.
like from 30 to 2020 it was there. And up to 2020, I could not utilize it because of the introduction of the GST in 17, 3 years, I could not utilize the balance payment. So they said that you can apply for extension of the period, not amount. And if the finance taxes department feels that yes, it is necessary, then they can extend it for a period not exceeding 5 years. From 2020 to 2025 was the maximum period. It can be extended.
Yes.
Amount, so far as exemption
Benefit of the ceiling of the amount will remain the
will
same.
remain the same. Only period, only because they were aware, my lord, that the payment of the tax under the GST Act was reduced, and the input tax credit which was to be taken by the balance, whatever CGST Act, that can also be adjusted among the states. So ultimate payment was less under the GST Act, and thereby the reimbursement or the remission was also less under the GST Act. Now, my lord, I accordingly applied at page 214. On 18/8/2020 for extension of the period of my eligibility.
Okay. Now, what is the finished products that was being?
My lord, I mentioned it, my lord. The first paragraph itself, my lord. Huh? Well, you'll also see para 6 at page 30.
Yes.
For the manufacture of PP woven bags and sacks for the purpose of load admission. Para 6.
Yes. This is available. This is amenable to the benefits offered.
My lord.
This product.
This is not negative.
Okay.
Now, I applied for it, my lord, on 18/8/2020.
Yes.
Now, this remained pending. And on 9th November 2020,
It was granted.
no, an amendment was made.
Huh?
An amendment was made, which you also find at page 216.
Yes. Yes.
Now, by this amendment, my lord, this proviso, which was there, was deleted. No, I'm sorry. I'm coming to that. My lord, it remained pending. And thereafter, my lord, you'll also find that one of the industry units, one of the industry unit was granted the exemption, the concession, extension on 9th of November 2020, which you'll also find at page 216.
For a period of 5 years.
5 years.
Okay.
Now, my application was 18/8/2020.
They remain pending.
It will remain pending. And 9th of November, to other industry unit, it was granted.
All right.
Now, thereafter, you'll also find at 217.
Yes.
An amendment was made to the scheme. Whereby the proviso, which was there, my lord, that was omitted. And you also see the savings. Notwithstanding the omission of the provision in the said scheme, as mentioned in clause 2 above, all orders issued thereunder by the Finance Taxation Department for extension of period of eligibility shall be deemed to have been validly passed as if the scheme had not been omitted. Further, all pending applications on which order in for extension of the period of eligibility has not been passed shall be deemed to have been rejected.
So your application remained pending,
My application remained pending.
whereas somebody else's application was granted.
Were granted.
And then this amendment comes and your application is deemed to be rejected.
They say all applications, whatever are there, they are deemed to be rejected.
Now you are challenging this
This, well, I'm challenging the
217
last part,
savings.
savings, that in fact, I'm challenging the notification itself, but my effect is that, my lord, that how one applications can be kept pending and without assigning any region, the other application is allowed. And thereafter it is said that whatever applications are there which have remained pending, that shall be deemed to have been rejected. Now, you'll also, if you look into the order at page 216, which was granted to other persons, there is no region.
Yes.
So to those persons whom the government wanted to give the extension, the extensions were given before omission of the said proviso. And after those orders were passed to those industry units, the amendment was made saying that all other applications are deemed to have been rejected. Now, my argument is only on Article 14 of the Constitution of India, that the classification which has been made in the present case between an industrial unit whose application, who submitted the applications and whose applications were kept pending, and an industrial unit similarly situated who filed an application and his application is granted without assigning any region, whether that classification can meet the below the Article 14 of the Constitution of India, and whether it is not hit by Article 14 of the Constitution of India. Well, it could have been there that 2 applications, 5 applications are there. One is allowed by assigning regions, because you'll also find the proviso says that they must come to a finding that yes, it is necessary and all those things. Now, one application you allow without assigning any region, and another application which is pending, you reject it by way of an amendment that they all are deemed to be rejected.
Yes.
Well, in my humble submission, this classification, they could have, prior to the amendment, considered all pending applications, passed and regional order, that we are rejecting this on this ground. A person could have approached this honorable court that another application has been allowed without assigning regions. Why my application will be rejected by these regions? Because in other case, no regions were there. But there cannot be an automatic rejection, which was the fault of the government to keep it pending. And just 1 month before you are allowing the petition of someone, my application which was filed prior to that, that is kept pending. That means this is nothing but an arbitrary exercise of powers to deny the benefits to some of the industrial units, whereas to give the benefits at its own sweet will to some of the industrial units, and thereby to bring the amendment and rejecting all the applications without any regions. So this is not a clear case of not only an arbitrary exercise of powers, because I can understand that the amendment and the scheme can be made by anyone. Nobody can dispute that amendment cannot be made. But by way of an amendment, you cannot take away the rights of one of the industry unit similarly situated with the other industry unit and give that benefit to another industry unit. And that too without assigning any regions. The
Yes.
proviso clearly said that if the Finance and Taxation Department is of the view that such extension is necessary for the purpose of sustaining the said industry unit, and the said industry unit could not avail the entire benefit between the specified period for the genuine regions, the extension will be granted. And that was also subject to a maximum of 5 years. Now, we're also aware when somebody says subject to a maximum of 5 years, then also it is imperative on the part of the authorities to state why 5 years, why not 2 years?
Yes.
As you'll also be aware of the judgments where the Malott, it was said that maximum penalty to the extent of 100%. And the 100% penalty was imposed. The division bench of this honorable court held that no, you cannot impose the 100% penalty unless and until you give reasons that it was such a case where the 100% penalty was required to be imposed. Here you are giving the benefit to someone of the maximum period of 5 years, and you are not assigning any reasons why you are giving the benefit to a particular industry similarly situated of the benefits without arriving at any conclusion which the department was required to arrive at before granting such an extension, and why the extension to the maximum limit was granted to a particular industry.
Yes.
In fact, this is a glaring example of the favoritism done to some of the industrial units similarly situated, and whereas meting out a discriminatory treatment to the another industry unit, which is on the same footing and which also applied for the extension of the time. Now, this is the facts of the case in short, and I am mainly relying on the Malott. In fact, I will rely on your lordship judgment given 10 days back on Article 14 of the Constitution of India. That Article 14
Provided it is applicable.
But that if it is not applicable, the law is applicable. That facts are maybe different,
right,
but the law remains the same. The law of Article 14 will remain the same, my lord. That it must have a rationale to the object sought to be achieved. Now, whether my industry unit was so bad or was not in the good book of the government that I was denied the benefit, wherever the other industry unit is such a good book that just before 1 month of the omission of the scheme, the government was very much aware the processing was going on. So before the omission of the scheme, the proviso, all others to whom they have been given, they have been granted. All those who have to be granted, they have been granted. And thereafter, the scheme has been amended to deny all other benefits. they could have said that whatever applications are pending and dispose of those applications by passing region orders. Whether to grant to some industry units, to discard to others, then that industry unit would have come to the High Court to say that what is the reasons of disallowing mine and allowing others. When I'm sitting the same footing, what are the reasons? So instead of going into all those things, a shortcut was found that to say that whatever is pending, rejected. Well, in fact, I've never heard of such type of amendments with that whatever are pending, rejected, and whatever has been allowed, that has been legally allowed. It says whatever has been allowed are legal, and whatever are pending, rejected. They could have said that no more applications will be entertained, and naturally, once it is omitted, the question of the filing the further applications does not arise. But with one stroke of pen, my lord, to pass such an arbitrary order, and making a subclassification amongst a classification is there, not the new industrial units, eligible industrial units. They are entitled to benefits. You are making a subclassification of those now, that one to whom we have already granted, and to another whom we have not passed any order, kept it pending. We will give the benefit to some industry units, and some industry unit will keep it pending and will not grant. Whether by virtue of the various decisions of the apex court and including your lordship decision, whether that can withstand the test of Article 14 of the Constitution.
Yes.
In fact, this is the short facts, and there is no question of to deny the in fact, when the matter came up earlier, 2 compilations were given of the judgments.
Compilation hai kuch? Binding. You can furnish soft copies, we'll take printouts, no difficulty.
Oh, I will give another copy. What is it? In fact, the judgments are the same which were referred to, my lord, in the
Essentially, your claim is that you had an accrued right
My
to be considered
my lord.
under the earlier.
As well as the legitimate expectation that my case will also be considered.
But legitimate expectation of being granted in terms of other similarly situated is one aspect.
That is
But
different.
essentially, your application ought to have been considered under the earlier,
My lord.
what is this, regulation?
Proviso what was there, my lord. My expectation.
When it was filed, during the currency of that particular.
And when after that you have granted the exemption to some other industries.
Any particular reason why it was kept pending?
No.
Perhaps it could be that there were certain communications exchange, nothing like that. Of course, the state has not filed their counter.
No,
So-
this is one case. This is not one case. This all the 10 cases, the same thing is there. It doesn't happen in one case. It may be that something is missed out. It cannot be missed out like that. You know?
It is not available. Perhaps it could be there in the
My lord, I will do
registry.
one
We'll
thing.
find out.
I will do one thing, my lord. I will prepare a fresh one. And I have also, my lord, subject to if your lordship can go through it before the next date. my lord, my written submissions, whatever are there, so that you also may, and whatever my learned friend will argue, Lord, I will prepare it, submit it, subsequent further reply to that one. Here I refer to, my lord, all the judgments which I am going to rely before your lordship, my lord.
Yes.
But main crux is, my lord, this is the issue, my lord. Whether the classification has a reasonable nexus with the object which was sought to be achieved. Whether the classification between the industries both filed applications and one was order was passed, another was kept pending. Whether that classification for the purpose of granting the benefits is a reasonable classification. And third, whether the industry has a legitimate expectation of consideration of the application before the proviso was omitted.
Okay. You give us a list of the citations which you'd like to.
So in fact, I will give it, otherwise in all this one effort, I will prepare another comparison below.
When can we continue again?
Well, my case, I will place all the judgments and only to refresh your lordship memories.
Okay, yeah.
I will be ready at any time.
Can we continue tomorrow? No.
Lordship, senior counsel may conclude his
There is no
part.
use, my lord. Because
No, the judgments.
judgments are placed, but if the arguments on the same day, completed.
No. What we're saying is you'd like to place the judgments.
I would like.
So would it be comfortable for you to do it tomorrow or some other date?
Some other day, my lord.
All right,
Immediately
then.
after you.
18th? 18th?
18th, my lord.
18th.
18th.
For further hearing. Heard Dr. A.K. Saraf, learned senior counsel, assisted by Mr.
PK Bora. PK Bora.
P.K. Bora. Learned counsel appearing for the petitioners. You are appearing for all the petitioners? All the petitioners. Mr. B. Chaudhary, learned standing counsel, finance, taxation. Represents all the respondents.
I think it was the Friday. The Friday. 18th.
Dr. Saraf has submitted that the petitioners essentially are aggrieved by the amendment brought in by the state of Assam, notified under amendment brought in by notification dated 30th of December 2020, which was Gazette notified on 30th December 2020. By the said notification, certain amendments were brought in to the
reimbursement scheme.
Scheme for reimbursement of tax paid under Assam Goods and Service Tax Act 2017 by eligible units located in state of Assam. The said scheme was earlier notified by notification dated 19 January 2018. By the subsequent notification dated 30th of December 2020, amendments were brought in to Clause 4, Roman 2, proviso to Clause 4, Roman 2. It is submitted that earlier under Clause 4, under the proviso to Clause 4, Roman 2, the units were permitted to file necessary applications for extension of the time limit for claiming the full quantum of, for claiming the benefit if they could not otherwise claim the benefit to attain the full quantum of the monetary ceiling due to some genuine reasons. Stop. If upon filing such an application, the authorities were required to consider the application and pass an order, and may, upon due consideration, by an order, extend such further time by a further period not exceeding 5 years. Stop. The petitioner had filed the application on which date was it filed?
Well, it was on 18 8 2020 at page 2014.
Filed on 18/8/2014.
20.
20. However, the said application remained pending, and subsequently the amendment was brought in, and wherein it was stated, amendment was brought in by notification dated 30th December 2020, wherein it was mentioned that all pending applications seeking extension of the period of eligibility where no orders have been passed, comma, shall be deemed to be rejected. Stop. It is this subsequent amendment whereby the applications pending were deemed to be rejected is under challenge before this court in the present proceeding. Stop. The further contention of the learned counsel for the petitioner is that although the application filed by the petitioner on 18/8/2020 remain pending, subsequent applications filed by other similarly situated industries were allowed. Stop. One such order that is referred to by the learned senior counsel is available at Annexure Roman 8, page 216 of the paperwork. Stop. Learned counsel for the senior counsel for the petitioner submits that this amounts to arbitrary exercise of power, as the petitioner's application, which was filed well ahead in time prior to the subsequent amendment, remain pending, whereas the on applications filed by other similarly situated person, orders were passed by the competent authorities of the respondents well after the application for extension was filed by the petitioner. Stop. Such classification sought to be brought in by the petitioner, brought in by the respondents, is without any basis and is therefore arbitrary and hit by Article 14 of the Constitution. Stop. Para. Mr. B. Chaudhary, learned counsel appearing for the respondent, submits that since this question is essentially a question of law, no affidavit. You have filed one affidavit.
One affidavit, Lordship.
Submits that,
Item number 24.
the department has filed an affidavit in WPC number
1586 of 2021.
1586 of 2021, and the same will serve the purpose of all the other writ petitions, and the department would rely on the said affidavit. He, however, submits that the petitioner that ठीक है. Second line to Narage. Para, the matter was heard at some length. Further hearing to continue on 8th. 18th.
Thursday.
18th of January 2024. This matter on 18, this bunch of matters, writ petitions on 18/8 as part heard.
Lord, one observation Your Lordship made that the others application were filed subsequent to one. My Lord, I have not submitted their
Okay.
application.
Similar applications filed by other similarly situated industries where the benefits were granted by the department subsequent to the
Filing.
application filed by the petitioner. List accordingly.